You appear for all the respondents.
Respondent number 2, Lordship. Intention.
Other respondents served or not?
Yes, strike out.
Only 2 respondents were there.
Yes.
Okay. The learned counsel for the parties are present. Full stop. Para, office note dated 4/3/2024 reflects that LCR has not been received as yet. The LCR was called for by the order dated 21/2/2022 when the appeal was admitted. Full stop. Para. Office to issue immediate office to issue fresh reminder for requisitioning the LCR.
Okay.
List after 6 weeks along with report on LCR.
May it please your Lordship. Lordship, I beg to mention item number 19 and 20.
19/20, yes.
Yes, Lordship, the matter may be posted after the vacation, Sir Lordship.
Here for?
I'm for the 19. Consent has been taken. Sir
No,
Lordship.
you're for whom?
I'm for the appellant, Your Lordship.
Appellant, okay.
If I am for respondent number 4, it protected.
Okay. On a prayer made on behalf of the applicant stroke appellant, matter is adjourned to be listed after the summer vacation.
Okay. May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 6 and 16. Lordship.
6 and 16, yes.
Sir. Letters may be listed after vacation. Lordship.
On behalf of Mr. Mullah,
Lordship.
okay. On a prayer made on behalf of the petitioner, matter is adjourned to be listed after the summer vacation. Alag alag, huh? 6 and 16. A petitioner, nahi, appellant, dono mein. Not petitioner, appellant, yes.
Your Lordship, I beg to mention for listing,
Yes.
Lordship, I beg to mention for listing, Lordship.
Fresh matter.
No, Lordship.
Then
Uh,
when? Listing when?
After vacation, Lordship.
After vacation, you could have mentioned after the vacation. Now the vacation. Okay, you may make a mention after the vacation. What matter?
Lordship, I have filed an IA for releasing the amount.
Okay, we'll have it after the vacation, immediately after the vacation. Give a date. You have it on 19th of July. Puntu, tomorrow? No. Okay. Police. 18, huh? Please before any other bench without me. 18.
I did 48. 40 is.
May please, Your Lordship. My Lord, in a compelling situation, my Lord, we have to approach this on court by filing this revision petition. My Lord, the suit was decreed based on a invalid said deed. And we have filed appeal. Appeal was returned. My Lord. There was a stay initially,
Petitioner is the defendant.
dependent.
Suit
There was a
for?
stay, my Lord,
Suit for?
suit for recovery of possession. Based on a, my Lord, invalid cell deed. Cell
No.
deed is not a registered cell deed.
No, that is your contention.
Yes.
They are basing their prayer on the basis of a cell deed.
Cell deed. Then, my Lord, suit was decreed and we have filed appeal. There was a stay initially in the appeal. Then, my Lord, appeal was returned.
Why?
Returned on the ground that the case suit is under specific relief act or under the provision of subsection 3 of section 6 of the relief act, appeal is not maintainable. So we in a compelling situation we file a revision petition. revision petition with some delay. And your lordship has issued notice on the condemnation petition. In the meantime, my lord, the execution proceeding, my lord, is proceeding, my lord, and we are apprehending that they may complete their my lord, execution proceeding. Therefore, we have filed this revision petitions, particularly against the my lord, execution.
We could have
proceeding.
filed a miss case in the pending
We
review.
have, my lord, since the condemnation petition is not yet to be disposed of, my lord, the CRP, that CRP is not taken up without any effective order against the execution proceeding. My lord, there is every chance of delaying the matter because of non-consideration of the condemnation petition. Notice has issued, my lord. That order has also been annexed in this petition, my lord. Annex 3. My lord, then my lord, we have approached
Now, this
the,
will amount to frustrating the court's usual court's process, don't you think?
my lord,
You had sought the remedy in law. There was a delay.
delay, my lord,
You filed an application for condemnation of delay. That is under consideration.
consideration.
Now, can you file a second revision?
My lord,
against the subsequent order.
because my lord, we have also approached the court below, informing that we have filed a revision petition, the execution proceedings should
Now,
be
what you could
suspended.
not,
That petition is rejected. We are against that, my lord.
but Mr. Sikdar, what you could not get directly, you are trying to get it indirectly. Is it possible? What is the order which is the subject matter of challenge here?
My lord, here, my lord, Annexure 6, my lord,
Page
page 51.
51.
Yes, my lord. 18/5/2024. So order dated. Decree holder side is duly represented. Judgment debtor side is also duly represented. Today was fixed for hearing on petition filed under order 21 rule 2629 date with section 151 of CPC filed by the judgment debtor side. I have heard both sides. It is submitted by the judgment debtor side that the instant case is filed by decree holder side for execution of decree dated so passed in suite number so. It is submitted.
Yes, please read.
My lord, it is submitted that during the pendency of execution petition, the judgment debtor side has preferred an appeal in the Court of Civil Justice Senior Division, Goalpara, which was registered as title appeal number 1/22. But due to jurisdictional error, the said appeal was withdrawn with liberty to file a revision petition in the proper forum, that is Honorable Guwahati High Court. Accordingly, on 13/12/2023, a revision petition by CRP 1533/23 was filed before the Honorable Guwahati High Court, challenging the decree dated 19/4/2021. It is further submitted that due to some technical issues, the said revision petition is still pending at the stage of admission hearing, and in the meantime, the judgment debtor side came to know from the reliable source. The decree holder has submitted the writ of possession and matter is fixed for report on 18/5/2024, that is today. It is furthermore submitted that if the decree is executed, the very purpose of filing the aforesaid revision petition will get frustrated, and the judgment debtor will suffer irreparable loss. Thus, it is paid to stay the execution decree dated so passed in this title sheet number so until admission hearing of the admission
But
of.
see the reasons at page 52, last paragraph. Page
My lord.
52.
Yes, my lord.
It transpires.
It transpires from the record that as despite being provided with ample opportunities, the judgment debtor side failed to submit the written objection. Writ was issued in this instant case by order date. It is further pertinent to mention that it is well settled that mere filing of an appeal or revision cannot be a ground for staying the proceeding of a case unless there is a specific order staying the operation of the said proceeding. Admittedly, the revision petition file is still at the stage of admission hearing. Consequently, in the absence of any order staying the proceeding of the instant execution case, I am not inclined to allow the prayer of the judgment debtor side, as I am of the opinion that it will cause prejudice to the decree holder, depriving her from the benefit of decree. Accordingly, petition number so is rejected.
And the process has not been able to be executed, so there is no immediate urgency.
Well, they are likely to kindly
see.
have a look at the subsequent paragraph.
Yes, furthermore,
Furthermore, a report is received from the Nazi.
Najib stating that
Nazi
the process
stating-
could not be executed and praying for provide police aid
Police-
as well as assistance.
My lord, on due consideration, the pair is allowed. Degree holder site shall fix. My lord, 29(6) for report, my lord. The report is, my lord, now, I think, my lord, it is available and there will be order for final execution, my lord. Today is, my lord, 26, day after 2 days, my lord. So, my lord, ultimately, my lord, our revision petition pending before this small court will be in factors, my lord. Will be prejudiced, my lord. Till then, my lord, may be considered for stay.
Specifically, section. The suit was under what? What provision?
My lord. Suit for, my lord, recovery of possession, that is subsection 3 of section 6 of the Specific Relief Act.
6(3).
My lord, subsection 3 of section 6. No appeal shall lie from any order or decree passed in a suit instituted under this section, nor shall any review of any such order or decree be allowed. So in that situation, we would have to, the appeal was returned and we have to file a revision before this now. Let us take them. Double bed below.
Let us see your suit.
My lord, আমি
Plain.
এটা কাকে নিয়ে My lord, we have my lord, we have not annexed the plain here, but in the other petition we have annexed the plain. But you may kindly have a look at here. We have not annexed it, but we have annexed the judgment only. It's important. Order of the
And the delay is 562 days.
Yes, my lord. Because we filed appeal was initially, my lord, there was admission and there is a stay also. Subsequently, after 1 year, the court has returned the appeal, my lord. So that way, my lord, the Punavati, my lord.
Heard. Sri A.R. Sikdar, learned counsel for the petitioner, who by means of this petition filed under Article 227 of the Constitution of India has put to challenge an order dated 18/5/2024 passed by the learned civil judge, bracket Junior Division, Gwalpara, in title Execution Case Number 5 of 2021, arising out of title suit number 47 of 2014, full stop, by the impugned order, comma, the petition number 288 filed by the petitioner for stay of execution of the decree has been rejected. Full stop, para. It is contended that in the suit filed under Section 6 of the Specific Relief Act 1963, the petitioners has submitted, were the defendants, and the suit was decreed, full stop. Initially, comma, the aforesaid decree was put to challenge by way of an appeal, being title appeal 1 of 2022 before the learned civil judge Gwalpara, which, according to the learned council, was also initially was also admitted, and there was an interim protection, full stop. However, subsequently wide an order dated 17/5/2023, comma, the suit was disposed of, or the appeal was disposed of on the ground that no such appeal is maintainable under Order 6, Rule 3, under Section 6 within bracket 3 of the Specific Relief Act 1963, full stop. Thereafter, comma, the petitioner had preferred a revision before this court with a delay condemnation petition in which notice has been issued on 14/6/2024, full stop para. In the meantime, comma, the execution proceeding had developed, and as a result thereof, comma, the petitioner had filed the aforesaid petition number 288 of 2024, which has been rejected, full stop para. Let notice be issued, returnable on 19th of July 2024. Let steps be taken for service of notice upon the sole respondent by registered post with AD. The learned council is also directed to take steps by Dusty, which is to be routed, so and so. Next date was likhta hai, affidavit, okay. Para, heard on the interim prayer, full stop para, considering the facts and circumstances, and also the instance whereby the original decree of the learned trial court was the subject matter of a title appeal, which continued for about a year, comma, till the next date, comma. Further proceedings in title execution case number so and so shall remain suspended, full stop para. The aforesaid interim order, however, would be reconsidered on the returnable date.
Deeply above.
এখন ঘুরাই দিব।
Malada defendant in the suit, Malada money suit for 4 lakhs. Malada, it was defense witness was closed, Malada.
Just a minute. Petitioner is the defendant.
Defendant, Malada.
Suit for money suit,
Money suit, Malada.
for recovery of money.
Recovery of 4 lakhs of rupees.
Mm.
And Malada,
Then
defense witness is closed, evidence is closed,
evidence closed.
Malada. Because Malada, I could not present the defense witness on the right time. Page 13.
You did not give any defendant witness.
Malada, I gave the defendant witness.
Then
Malada,
No,
there was a order.
no cross-examination.
No cross.
So it was closed, expunged.
That is why I am before your lordship, my lord. Only ground is that, my lord, the next day on page 13, your lordship will find.
When did you adduce when did you file the affidavit?
My lord,
When did you file the defense affidavit?
my lord, that is not then, my lord. What is stated, my lord, the day I brought the evidence.
Suit is of which year?
Suit is of, my lord, title suit of 15, my lord. Money suit of 15.
15.
My lord, then it was renumbered as 21.
No, money suit of 2015.
Then it because of jurisdiction issue,
We are not on the judiciary. It's from 15, 1% is running for 4 lakhs of rupees.
Malad 21, then it was money suit of 21 now.
We are not on 21, we are on 15. When did the cause of action arise? When did they,
Malad,
when did 25
I
approach the
admit,
court?
Malad, only thing,
2015 to 2024,
Malad, because that
running from pillar to post
because
for
I am
4
a
lakhs.
government employee, Malad, I was not been allowed to come, Malad. Leave was not granted. That was my only reason, Malad.
Suit is of 2015.
Or some consideration,
This
Malad.
is a fact which is totally against you. Then when did you file your affidavit?
Malad, affidavit was
When
filed
was
early.
PW closed?
Malad,
When was PW closed?
PW was closed earlier, Malad. That
Obviously earlier, when?
PW किसे close हुई थी? PW when was closed? 20 fitness कौन close हुई? Twenty fitness तो date तो दिया है. Those dates are not here, Malad.
Then why, what?
Malad, only
is
thing is
that-
this, Malad, the orders that has been placed here is that, Malad, on 16/5/24, page 13 is the order, Malad,
1-3.
1-3.
Yes. This is the order you're impugning.
Malad,
16-5.
Malad.
16-5-24.
Defense witness was closed on 6/11/23, Malad. Then it was allowed for paying rupees 2,000. Then, Malad, on next page, your lordship will find on 7/6/24, I brought the witness. 7/6/24, but it was not allowed because it was the earlier day, it was closed. Page 14.
You did not submit the cost also.
If the defense side is closed, cross for the defense witness. Malad.
No, after the read the third, fourth paragraph, after that, the defendant side filed
Filed
the
a petition
petition to
for
reopen,
reopen of the defense.
which was allowed by the court with a cost of rupees 2,000 as per order. Today also, the defendant witness, side filed the petition to bring witness, neither he has submitted any cost.
Some reluctance is there, Malad.
Not some,
Malad, with some
Gross.
consideration.
gross.
Malad, I understand.
Gross,
But I have
gross.
filed also filed title suit. This money suit is a total frivolous, Malad.
That, where is your conduct?
I understand, Malad. Please, your lordship will just consider this. I will pay the little bit of cost, Malad, and I will.
Little bit, you pay 4 lakhs of rupees, matter ends.
Malad,
No need of-
I have filed a suit and thereafter this suit has been
No need
filed,
of paying cost.
Malad, because I have filed a suit in counter to that he has filed a suit. And it is there in the plaintiff.
Mr. Rao Chaudhary, tell us, how do we stay this order? What is wrong with this order?
Malad, I only pray your lordship may.
What message will go from the High Court? That we can't even act as per law.
Malad, your lordship may look into the plain. It itself shows.
No, we are not going into the merits, we are on the conduct, and you are seeking interference with an order by which GW has been closed after repeated opportunities.
I
You impose
understand, Malad.
cost, you did
Only
not,
thing-
don't even deposit
Only
the cost.
thing is that page 55, your lordship will find that Malad, leave are not granted to me because I'm a government employee.
When is the next date?
Malad, next date is Malad 12/7.
Government employee from 2015, you can conduct your own suit, then you are granted leave. You have
Well-
just said,
12/7/24, Malad.
you have said that you have filed a suit.
Malad,
For that, you get time.
Malad,
As a defendant, you do not have the time.
12/7/24, Malad.
12-7. Will not like to stay this order, Mr. Rao Chaudhary. A very wrong message will go.
Otherwise, Malad, it will fix for argument and it will be disposed of, Malad. I will be severely prejudiced, Malad.
Not severely prejudiced. You have invited. 6/11/2023, it was closed. You file application, it was reopened on cost. You don't pay the cost. How long?
Malad, I understand, Malad. Your lordship may just give me one chance, Malad. Last opportunity. If I don't appear on the next day with the witness, Malad, with the cost, Malad, your lordship may place.
But we are not going to stay this.
Otherwise, on
No, we are not going to stay this. We want to dismiss this, but at best we can issue notice, making it returnable on the reopening, and we are not going to stay this. If the other side appears, we can think of imposing some heavy cost upon it, and we may, not before that. heard Sri P.K. Roy Chaudhary, learned counsel for the petitioner who
My
has,
lord, your lordship, just consider, my lord, that I may obtain a leave on that day, my lord. My lord, they may adjourn the case because of the High Court pending.
no,
Otherwise,
we will not advise you what to do. You know what to do.
my
We'll
lord,
not-
I will
And
file
with,
an
with this kind of conduct, we are not going to say anything. Who has filed this application under Article 227 of the Constitution of India, challenging an order dated 16/5/2024
and subsequent date, my lord, 7/6/24.
and the subsequent order dated 7/6/2024.
That day I brought the witness, my lord.
Full stop, para. The petitioner is the defendant in title suit, in money suit number 3 of 2021, which was full stop. The suit it appears that the suit was originally instituted in the year 2015 and was renumbered in the year 2021. Full stop. The plaintiff evidence was over and the matter was at the stage of the DWs. Full stop. It, however, appears that the DW was closed wide and order dated 6/11/2023 as the petitioner could not produce the witnesses. Full stop. The impugned order dated 16/5/2024 further reflects that the matter was reopened wide and order dated 30/3/2024 with a cost of rupees 2,000. Full stop. However, on the date when the order was passed, that is 16/5/2024, the witnesses were not produced and a petition was filed. Full stop. It is reflected that the cost was also not deposited. Full stop. Accordingly, the impugned order was passed, closing the evidence of DWs. Full stop. By the subsequent order dated 7/6/2024, the subsequent petition was also rejected. Full stop. The learned counsel for the petitioner has submitted that on 7/6/2024, the witnesses were produced. Full stop, para. Let notice be issued, returnable on 17th of July 2024. Let steps be taken for service of notice upon the sole respondent be taken by registered post with AD. You serve Dusty also?
No.
Dusty, huh? Same, an affidavit. You need to file affidavit before the next date.
No.
Okay. Para, the prayer for interim order would be considered. No, on appearance of the party, Sri Roy Chaudhary prays for an interim order. Full stop, para. This court is, however, of the opinion that instead of passing an interim order, the entire matter would be taken up for disposal on the next date on appearance of the parties. You file affidavit before the next date, 17 we have fixed,
Oh, but
and take Dusty. Steps within 2 days, huh? उसमें लिख दीजिए, ऊपर में भी.
I think one.
No, the matter actually came up for consideration last year also. I was just asked to obtain a copy of the order. Well, here, what happened, my lord? I have filed a suit for SP department. That suit was decreed. Then, my lord, the appeal was preferred from that, my lord, that appeal has been decreed. Thereafter, I put the decree in execution.
Can just a minute, please.
Yes. Now a third party, my lord,
Petitioner is the plaintiff.
my lord,
Petitioner is the plaintiff.
no, petitioner, original suit, I was the plaintiff, not in this suit, my lord.
Okay, okay.
I filed a suit,
Now that petitioner is the defendant,
defendant number 3.
D3. Then
He
initially,
obtained a decree, my lord, which was affirmed by the appellate court, and he put into execution.
just let me note it. Initially, you had instituted a suit.
Yes.
Petitioner earlier filed suit for
Suit for state performance of contract.
specific performance. Okay. Then decreed,
That the decree, then appeal was preferred,
decreed affirmed.
Yes.
Affirmed by appellate court.
appellate court. Now,
Yeah.
my lord, we put that decree in execution.
Hmm. Okay.
Now, the third party, my lord,
Okay. Decree put to execution. Thereafter,
third party put, filed a suit challenging the decree, my lord.
fresh suit,
Fresh suit.
not
But
under
This cannot be filed, my lord, under, as
Twen-
per order
21,
21 rule 101.
97, 101.
Yes, 101, my lord.
Oh.
And there is a, my lord, last time, the court, my lord, I brought that judgment of Supreme Court also. No separate suit can be filed, my lord.
Okay, then
Then, my lord, in the suit, my lord, I was defendant number 3, but, my lord, due to some fact in the summons, my lord, I could not get it. And, my lord, the suit proceeded ex parte against me, and injunction order was passed. Then I approached this honorable court, my lord, this honorable court allowed me to file written statement. We filed the, my lord, written statement.
okay.
Then we prepared an appeal, my lord, against the injunction order,
Yes.
and that appellate court, my lord, affirmed that injunction order. Now, my first point is this, my lord, the suit itself, there is no prima facie case, my lord, because the suit is not maintainable in view of order 21 rule 101, my lord.
Appeal has been dismissed.
Appeal, my
Your
lord,
appeal has been dismissed
appeal.
against the injunction.
Yes.
Okay.
My lord, I am just relying on the judgment of, my lord.
Injunction was granted when?
Yes. Injunction was granted in 2018, my lord, then. appeal was-
Date.
Yes, I am giving them. My lord, 27/6/18,
And rejection of appeal?
appeal, yes. No question. 10/1/2022.
What is the stage of the suit?
Suit, my lord, I think we have filed a written statement only. My lord, till now, nothing.
Madam
has-
Chaudhary, what is the stage of the suit? Where your suit is of which year?
2015,
2015?
yes.
Yes, sir.
Your suit?
2015, but my lord,
Yes, it is
uh,
2015.
it proceeded ex parte against us, my lord, so we have to obtain an order from this honorable court.
No, that is okay. You had filed written statement.
In
Now that
2019, we have obtained the order.
suit is of 2015.
Yes,
We direct the suit to be completed within the next 6 months.
my lord, no, yes, my lord, first thing we have to preliminary point is to be decided, my lord, because I shall place
Now,
my,
you have taken into this in your written statement.
my lord,
The maintainability point.
Yes.
You must have definitely taken in your written statement.
now, my lord, at the time of injunction also, this point is to be decided, my lord. I'm just.
Now, see,
placing-
Mr. Sawala, what we are thinking, the injunction is of the year 2018, affirmed in the year 2022.
Yes.
Now 24, instead of going to the aspect of injunction, suit to the 15, First appeal, pecuniary jurisdiction.
Yes, correct.
Okay.
My lord, at page 66. your
Page
lordship will see.
66.
Yes, the order starts at page 59,
59.
59.
Yes, please.
And the operative part of the order is at page 66.
Order is dated 6/2/24.
Yes.
Yes,
Now, my lord, at page 66, I'm taking your lordship directly on that one.
yes.
This is a suit for declaration of the electric connection granted in favor of opposite parties and people is illegal and for marriage indifferent. In support of the plea, both parties submitted some documents. From the pleadings as well as documents, it is seen that the both parties are claiming ownership as well as the possession of two states. The petitioner by way of will that is person such, and the opposite party number 3 by way of ownership is the deed of exchange for sale dated 209/21. It is seen that the both parties have challenged this deed and the matters are pending in the court of additional district judge number 3 and civil judge number 1. It is seen that the electricity is in the name of opposite party number 3. For ascertaining the ownership of the two claims, proper adjudication of the matter in issue is required. At this stage, if the injunction is not granted, the petitioner does not intend to suffer loss and hardship. But if the injunction is granted, the opposite will suffer more hardship as electricity cost under essential amenity, which will cause untold harassment if it is disconnected. My lord, here is the question, my lord. I was in position, I got this two plane by way of bill, and bill has already been provided in the court. Now they claim that they purchase by on the basis of the agreement of sale, my lord. The agreement of the sale, my lord, that they have claimed it on the basis of the agreement of sale, my lord. So far the agreement of sale is concerned, my lord, that does not confer any ownership within the purview of section 54 of the contract, Contract Act, my
Is on the basis of what?
agreement for sale.
Agreement.
Agreement for
There is no sale deed.
no,
No sale deed.
no sale. And under section 54 of the Contract Act, my lord, it does not confer any kind of title so far the defendants number 3 and 4 are concerned, my lord. Now, my lord, your lordship is
Very like protected.
transfer of property. Sorry, not contract, transfer of property. 54. I got it, man. Now, my lord, last one. Contract for sale.
Yes.
Contract for sale. It is agreement for sale or contract for sale is one and same thing. my
Yes,
lord.
yes.
A contract for sale of immovable property is a contract that is a sale of the property shall take place on terms settled between the parties. It does not of itself create any interest in or charge on such property. So the agreement for sale does not confer any kind of title so far the other side is concerned by. First doubt. Second, my lord, it is not properly
No, Mr. Bhatti, these are grounds on the merits.
made.
But on the injunction part, when it's a
My lord, for coming to the case whether they will suffer any kind of irreparable loss.
yes.
If they
Now
are not,
you
if
are
they are
you are praying for an injunction to disconnect electricity.
electricity.
Now, is there
Because
can there be any question raised that he will not suffer irreparable loss by
No,
disconnection
no,
of?
my lord, now certain rules are there. So far, The connection, in what circumstances the connection can be given. It can be given. For this particular purpose, may I take a lordship?
No, Mr. Bhatti, we are not on the issue whether electricity connection has to be granted or not granted. It's already been granted.
Right.
Now you're asking that by an injunction,
No,
it should be
not
disconnected.
Yes.
It should be disconnected. Now, unless the APDCL comes up with a plea that the connection has been taken illegally, then you have a case.
Yes, my lord, that they did not file any kind of WS.
It's not their case that they have taken it illegally.
No, it is no.
If only electricity connection is taken illegally, unauthorizedly, then you can get a
My
order
lord,
for
whatever-
injunction. But electricity being an essential commodity, can you?
Yes, my lord, to that extent, I agree with your lordship. But so far, the electricity, APDCL is
You are,
concerned.
you are
Lordship,
staying there.
Moreover, the
Are
probate,
you staying there? What is the kind
yes,
of?
I am in possession of the property, Lordship. There are two suits. Certain facts have not been properly placed
No,
in
it is
possession
okay,
of a court.
Now, Mr. Chaudhary, tell us
Yes.
one thing. What
Yes.
is the property about?
Exactly. Now I am saying, Lordship, what my learned senior friend is saying about the probate of the will, granting of the
We
probate.
are not on
Now that has
those.
been revoked. Now on what
No,
authority?
we are not on
Yes,
those. What
yes.
is the kind of suit? What is the kind of the property?
Property is a landed property, and the person, by virtue of that particular sale agreement, has handed over the possession over the land. And I am in possession of the land, and for that reason, they have filed another suit
No, no.
for recovery of
Again, you are
possession.
going to some other tangent. We
Yes.
are not on that. What is
Yes.
the kind of the property? Is it a house, residence? What?
Residential house.
Residential house. Tell
Residential
us that.
house.
So
Yes.
electricity is necessary.
Exactly, Lordship. Residential
Tell us
house, I am
that.
staying there, Lord.
We are not on landed property. A
A
piece of land
residential
may not
house
be.
since 2021, I am in
Ah.
possession of the land.
Suit of the which year?
This is recent 2020.
Subsequently, they have filed another suit. One suit they have filed for recovery of possession, and the second suit they have filed for this one. This electricity,
This
disconnection
suit
of the
is
electricity.
23 miles.
The main prayer in this suit is for disconnection of the electricity, and the injunction also is for the disconnection of the electricity. And the will.
Mr. Bhatti, you know the limitations of a appellate court in an injunction matter.
My lord, I will satisfy your lordship that even at mandatory is in. suitable
And that
cases-
too, you are asking for disconnection of electricity. I think.
Yes, my lord, because the connection was given unauthorizedly by the
Okay,
APDCL.
we'll close this.
APDCL. And on the basis. that-
Yes, decision, wandered and talks.
That decision I'm not taking. Lord.
What are you doing? Where is Ramdev Foods? At least bring Wonder and Talks. Which one? Wonder and Talks?
These are recent, very recent.
Oh, no, not on that. We are on the powers of the appellate court while deciding an injunction matter. You don't bring Wonder and Talks, you don't bring
Yeah.
Ramdev Foods. How do you assist the court?
Lordship, then at 2, I'll produce
What
it.
at two? You may have the time, we don't have the time. Okay.
My lord, let it come just after.
No, it will not come. After today, it will not come. It will not come after today. Today is the last date.
In that case, my lord, let me ask.
We are not going to change our mind.
If your lordship.
Injunction matter, and that to disconnection of electricity you are seeking. This is too, I think, harsh, very harsh. I think personally also you are not supporting this. It's a different matter. You are espousing the interest of your clients, but will you support somebody disconnect electricity in this heat?
Let it come.
We are recording your submission.
Let it come.
We
any
are
other
recording
day,
your submission.
Let it come.
Strenuous arguments,
Any other day.
vehemently contended.
Let it come any other day, my. And.
We don't
after-
want these matters
in,
to.
in first week of August, my lord, and I will satisfy your lord.
You also have a very peaceful vacation. Let them also have some peace in the vacation.
Let them enjoy the electricity till then.
Peaceful, enjoying till after the vacation. Again, it will come. Again, there will be a
No.
sword
because-
hanging.
Whether the injunction can be granted or not, regarding that.
Let us finish this.
Let it come in the first week of.
You can argue for some time. We're not going to adjourn.
My lord, the others are waiting. For that time.
Argue.
So
I
that
will
my
we'll
lord,
give you another 10 minutes time. No problem.
No, it I may not.
Because
be
we
able-
are not going into the merits, as you
No.
know. We are not going to cause prejudice to you. It's for you to fight in the suit. Here we're not going to make any observation which will go into prejudice either of the parties. We are confining our observation discussion only to the principles governing injunction, that's all. And the commodity involved, that is electricity.
Then your lordship,
Third, three, please have a seat. O.P. Bhattil and counsel for the petition appellant. Of course, I've also heard Sri S.P. Chaudhary. You're for the first response, R. Bora for the respondent numbers 1 and 2. R. Bora, London Standing Council, APDCL for the respondent numbers 1 and 2. And
and
Sri
four.
S.P. Chaudhary,
Three and-
London Council for the
Three and
respondent numbers 3 and 4. Para, considering the subject matter involved in this appeal, comma, the appeal is taken up for disposal at the admission stage itself, full stop, para. The appeal has been preferred under Order 43, Rule 1R of the Code of Civil Procedure against and order dated 6/2/2024 passed by the learned civil judge, Senior Division number 2, Kamrup M, in Ms. J case number 233 of 2023, arising out of title suit number 134 of 2023, full stop. Para, the projected case of the appellant, who is the, appellant, which is a registered society, and is that as plaintiff, a suit was instituted for a declaration that the grant of electricity connection to the respondent numbers 3 and 4 by the respondent numbers 1 and 2 is illegal. Full stop. It is submitted that the suit land in question had devolved upon the appellant plaintiff by following the due process of law in terms of a will which was duly probated. Full stop. However, only on the basis of an agreement to sell, comma, the defendant, the respondent numbers 3 and 4 has taken forceful possession over the suit land. Full stop. The learned counsel for the appellant has also referred to the provisions of Section 54 of the Transfer of Property Act 1882 and has contended that a contract for sale by itself would not create any interest or charge on the concerned property. Full stop. It is submitted that other than the agreement to sell, comma, there is no other basis on the part of the defendant numbers, respondent numbers 3 and 4 to claim ownership. Full stop. Para. S.P. Chaudhary, learned counsel for the respondent numbers 3 and 4, has, however, submitted that the contentions advanced by the other side are on the merits of the case, whereas the instant appeal is against an order by which injunction has been refused. Full stop. It is submitted that the injunction sought for was for disconnection of electricity, which was duly taken by his clients from the APDCL. It is submitted that that even before the contentious issues are decided by the learned court in the suit, the injunction has been sought for, which would amount to grant of final relief, which is against the principles governing injunction. Full stop. Para. The learned counsel has also submitted that consideration of a matter of injunction involves discretion, and in the present case, such discretion has been exercised in the due process, whereby the three golden principles have been taken into consideration, and Vide, the impugned order dated 6/2/2024, injunction has been refused. Full stop. He has highlighted the aspect of a limited role to be played by the appellate court in matters of grant or not grant of or not granting of injunction. Granting or not granting of injunction. Full stop. Para. Sri Bora, the learned counsel for the response number 1 and 2, the APDCL has submitted that he would not have too much of a role in the suit. Full stop. However, on a specific query made by this court, he has replied that prima facie, it appears that the connection was taken by following the due process. Para. The rival submissions have been duly considered. Full stop. Para. Vide, the impugned order dated 6/2/2024, the prayer for injunction has been rejected. Full stop. As noted above, the injunction was for disconnection of the electricity to the premises of the responsibles 3 and 4. Full stop. Though the learned counsel for the appellant has raised serious contentions with regard to the right, if any, of the respondent numbers 2 and 3, 3 and 4 over the suit land, the nature of the injunction is with regard to the electricity connection. Full stop. The discussions made by the learned court while granting the injunction is on the aspect of suffering of hardships, as electricity is one of the essential amenity. Full stop. The aforesaid aspect, in the considered opinion of this court, is a relevant aspect germane to the issue, and therefore this court is of the opinion that such a view taken by the learned court is a reasonable view based on cogent materials and grounds. Full stop. Para. The Honorable Supreme Court, in the case of Wonder versus so and so, has laid down as follows. Full stop. The aforesaid principles have been reiterated, and in the case of Ramdev Foods, the following has been laid down. Full stop. Quote Koriba. Para. The power and jurisdiction of an appellate court in matters of injunction is limited. Full stop. As laid down by the Honorable Supreme Court, the appellate court should go slow in matters of granting or not granting of injunction, and only if a case of perversity or gross illegality is made out, an appellate court may, in an appropriate case, interfere. Full stop. However, such interference should be done in a sparing manner. Full stop para. In the instant case, comma, as noted above, comma, the order dated 6/2/2024 by which the injunction has been rejected pertaining to a prayer for disconnection of electricity appears to be in order, which does not require any interference. Full stop. Appeal is accordingly dismissed. Yes. এটা হেৰি আছে আইয়ে ক্লোজ কৰি দিম Yes.
My lord,
Item
Uh,
number,
as per the process service report, the notice has been served on the daughter-in-law of the respondent.
Mr. Bhattacharjee, you're for whom?
Respondent number one is present.
Okay, one, and who's two?
Who is the owner of the boat? Owner of the boat,
Owner of the,
River Cruise.
this is under the Employees Compensation Act.
Yes,
Okay, you're the insurance company.
we are insurance company. And in this particular case, my lord, insurance company issued one marine hull policy. Not
Uh,
a motor policy or WC policy. It is a marine hull policy issued against a river cruise. Name SB Johra Khatun is
No, it has
the,
come up for the first time.
pardon,
Appeal has come for the first time.
Yeah.
There was a delay condemnation. Delay has been condoned.
the delay has been gone.
Delay has been condoned.
Now appeal
Because
has
since
come for the
there was
first time.
First
My
time.
lord, since there was a report from the office note that notice was not served upon the respondent number 2,
Where? In which case?
this one in IML.
I is for stay. No, there is come for the first time. There is no office note. That was, I think, in the delay condemnation.
This delay.
Delay has been condoned.
Yeah, the delay was condoned.
No,
That's
so
not-
we are having this for the first time.
It will come for the admission, my.
It is come for admission only.
Yes.
Mr.
Judging
Das, Mr. Das, this is
Lord.
under, this is. Appeal is under section 30, isn't it?
Yes.
Where are your substantial questions of law?
Substantial question of law is whether the findings of the learned commissioner employees
not sure.
compensation Kamrup is perverse in
Huh?
holding that.
I have not received the memo of the appeal also.
You serve him a copy.
Today-
Otherwise, for admission, there is no requirement. You, for where is the substantial, which one?
Today,
have-
today will.
No, where is the, which is the substantial question? Amongst the grounds?
Whether
Which one? Which one? Serial number?
serial number one,
One. Please read.
whether the findings of the learned commissioner employees compensation Kamrup is perverse in holding that the opposite party number 2 United India Insurance Company is liable to pay the compensation notwithstanding specific exclusions under the hull and machinery policy inland vessels to cover workmen's compensation. Number 2 is whether the commissioner is justified in presuming that the workmen's compensation is covered under hull and machinery policy inland vessels in total disregard to the terms and conditions of the
Same,
exclusion.
this is the same. Same as what you have just now read.
Yes.
You say that your policy does not cover this machineries of hull issue. What is a hull?
Hull is a, when we cover a ship or a boat or a river cruise, hull policy is issued for the damage to the.
It's the name
particular
of a policy.
Name of the policy is
Well,
marine hull machinery policy.
Okay. Have you made the deposit in the commissioner? Before the
No,
commissioner?
no.
You have to make a deposit,
No,
have a
the
certificate.
insurance company is exempted from depositing
Which decision?
while preferring appeal.
Which decision? Which decision?
Decision I am at this moment, it is not ready with me, but it is there.
No, you may be correct in contending.
Insurance company,
There is also a decision we can say, but where is the decision?
insurance company is exempted, but when the employer comes, he will. have to deposit.
Yes, contending that will not do. You have to show the decision.
My lord, give me some time, I will give the
Okay,
decision.
in the meantime, you can give a copy to Mr. Bhattacharya.
Okay.
Otherwise, admission we would have done without even hearing it, there's no requirement. But you have to give the decision,
Oh, sure.
okay? Part 3 A and Das, Learned Counsel for the appellant, whereas 3 K Bhattacharya, Learned Counsel for the respondent number 1 claimant
Yes.
is present, is also present, full stop para. Sri Das, the Learned Counsel, prays for and is granted 2 weeks' time to formulate draft substantial question of law. Full stop. In the meantime, comma, let a copy of the memo of appeal be furnished to Sri Bhattacharya,
Obliged.
the Learned Counsel for the respondent number 1.
Deeply obliged.
Okay.
Right, Praise the Lord. If this matter is about decree for declaration of possessory right, agreed by the order of the Honorable Trial Court, okay, you have come before this Honorable Court for with a prayer for granting ad interim injunction. My Lord, the facts of the case is that
You have filed under section 6 or what?
yes, understand.
Of the specific relief act. You are the plaintiff.
I'm the plaintiff.
Appellant is the plaintiff. Suit under section 6,
6.
specific relief act. Then suit, what had happened? You filed injunction also.
You have filed an injunction.
Injunction has been declined.
Declined only on the ground that parallel proceedings is going on in the form of fire. That is
In the
only
form
ground-
of
in the form of FIR.
FIR?
FIR, that is the criminal proceedings that is going on. That is why the Learned Trial Court has considered this aspect. Your Honor.
What is the stage of this criminal case?
Notice has been issued here.
No. In the criminal case, what kind of criminal
Criminal
case?
case charge sheeted, Lordship.
Charge sheet.
Charge sheet.
Investigation is over.
Investigation is over.
Matter is in the court now.
Matter is in the court.
Summons issued.
That I don't know, Lordship, but it has been charge sheeted, which I have annexed, your Lordship.
This FIR was lost by whom? Other
FIR
side.
was lost by us, the appellant.
Okay. Now, where is the discussion? Let us see.
Discussion. You have purchased this land, my lord, in the year 1999.
Page.
Page 32, my lord. Is the sale deed, unregistered sale deed.
No, where is the discussion in the impugned order?
Lordship.
Which page?
104.
104.
Page number 104.
104.
The operative part is on number 6.
This order is a 16/5/2024.
Yes.
102.
Yes, ma'am. Kindly turn to page number 103, my lord.
Just a minute. 16/5/24. By which court? Civil Judge,
3,
Senior Division,
senior division.
3 Kamrup. Okay.
Put my phone.
Page?
103, my lord.
Yes.
Point number 5, that is the operative part. On hearing and perusal, it appears that there is pending litigation or affair amongst the parties in connection with the dispute. The petitioner admitted that though the OP agreed to sell out the whole Schedule A land, that is 1 Kotha 3 Lessa, by the unregistered deed signed on so and so date in the year 1999, but he has been given possession of 15 Lessa only as of now out of the total agreed land, that is Schedule A land. Thus, it appears that there is a long-standing dispute between the petitioner and the opposite party. There is no long-standing dispute here. This FIR has been filed very recently. Before that, there was-
What kind of injunction did you seek?
Lordship, on the Schedule B land, we are running business, Your Lordship. The two shop we are running, one in the form of departmental store and a restaurant. The respondent have trespassed to our land and they have actually stopped our business, Lordship.
No, what kind of injunction are you
Ad
seeking?
interim injunction, Lord,
What? An interim of
to
what?
restrain the opposite parties
From?
from Lordship. From any kind of nuisance disturbance inside the suit land.
But injunction as such has not been declined. Notice has been issued.
Notice
Your
has been
only
issued.
prayer for ad interim has been not considered, or considered and not passed.
Yes, sir.
But court considered that we will hear the other side.
Yes, sir. But Lordship, we are suffering a huge financial loss.
Now, what
Kindly-
kind of financial loss? What is
Because-
the injunction that we're asking you again?
Because
What kind of disturbance they are making? You are running, you said, departmental store and a restaurant.
yes, Lordship,
Now, you in the running of your business, what is the kind of disturbance?
they have put a bar on the entrance of the business of your Lordship. They have completely stopped our business.
No, that will not be an injunction. What kind of injunction will be? It will be a mandatory injunction kind of to remove the bar.
Yes, Lordship. But till then, at least we should be allowed to run the business. Sir.
Difficult. That is a mandatory injunction. If you are allowed to run the, what is an injunction? It's only to safeguard the interest of the party approaching the court and at time the other party also. Only to balance. Here you
Hello.
said that the wall has already been constructed.
Yes.
If they have constructed the wall, you cannot buy an injunction on that to ad interim, direct removal of the wall.
But it's a temporary wall.
Temporary or whatever, even a fencing cannot be removed like this. This will amount to mandatory injunction. And to make out a case of mandatory ad interim injunction, you have to have a very serious kind of a very positive, extraordinary case.
My Lord, I have kindly peruse the documents, my Lord.
When is the next date? 25/6. It's already over. What happened?
They have appeared.
Appeared then?
My Lord, but we are suffering financial loss, Your Lordship. There is a kindly,
Now we can make a request to the court, decide expeditiously. They have filed their objection.
my Lord, they will purposely delay the
No,
matter.
we'll have a day, fixed time. Nothing more than that. See, your injunction per se has not been declined. Ad interim has been declined. Ad interim declination does not mean that non-consideration. They'll consider the appropriate stage.
That is why I have come before this honorable court. That is why I have come before this honorable.
And what kind of order are you expecting today from this court? The best order, tell us. To remove the fencing or the walls cannot be.
Lord, it is law.
And the status quo, I don't think it will help you.
Status quo may be granted.
Status quo in one,
Please to run the business.
now that we cannot say. We do not know what is the present stage without hearing them. Are you still in position or not? That even we do not know.
Lordship, we are in position.
Where have you stated?
Lordship, it is there. My Lord,
Where?
kindly peruse the documents, Your Lordship.
Where, no, not documents. You show your pleadings in your injunction application. Well, when is the next date?
Date I have to take.
You don't know the next date. It was on 25/6.
25/6 we appeared.
Thereafter, what has happened?
Thereafter, they appeared. My Lord. They filed a wakalat.
Today is what?
Today is 26.
Yesterday was the date.
Yesterday.
Okay. Heard. Your name?
That's Kakoti.
Heard Sri S. Kakoti. Learned counsel for the appellant. Who, by means of this appeal, has put to challenge an order dated 16/5/2024 passed in Ms. J case number 436 of 2024 by the learned civil judge, senior division number 3, Kamrup, Guwahati, full stop. By the aforesaid impugned order, comma, the prayer for grant of ad interim injunction has been declined and notice has been issued to the opposite parties. Full stop. Para. It is contended that the suit has been instituted, that the title suit number 246 of 2024 has been instituted under section 6 of the Specific Relief Act. Full stop. It is submitted that the consideration for not grant of ad interim injunction is not proper, as lodging of an affair by the appellant would not be a relevant factor to decline such prayer for ad interim injunction. Full stop. Para. Admit. Call for record nilekhiba, huh? Let steps for service of notice upon the respondents be taken by, you take by registered posted AD.
Right.
By usual process as well as by registered posted AD. Steps within 2 days. Part 3. S. Kakoti, learned counsel for the applicant who has filed this application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure, in connection with title suit number so and so, huh? The appeal preferred against the order dated 16/5/2024, by which the prayer for grant of ad interim injunction
Hello.
has been declined.
May I press? Kindly, the prayer, my lord, in the interim, my lord. It is
Indeed,
in the interim, my lord. Can I make a prayer, my lord? It is pending disposal of the first appeal against order. First to pass order restraining the respondent, their main agent, and from causing any kind of nuisance disturbance inside the suit land. Shown as schedule below. And
page
25 in the FAO, man.
FAO, where is the scope?
My
We
lord,
are in the IA.
I also, my lord, I'll
Now we are considering the IA you have filed here under 39.
okay.
That is gone.
Kindly turn to page number 17.
Oh, listen to the order we are passing. Yes, it is.
Kindly have a look at the prayer, man.
Of page
17, my lord, of IA.
Yes.
You're just praying for restraining the respondent, their main agent, from causing any nuisance disturbance inside the suit land. That is our prayer. And order directing the party to maintain status quo in
Now,
response.
who will ensure this? How do you restrain from a person from causing any nuisance? How do you enforce this?
It is the status of the position of the land is this.
No. How do you enforce this? Suppose we pass an order, no nuisance to be created. Now again, it will be a matter of evidence. They'll say that we have not come. You said that they have come for creating nuisance.
Let it be, my lord. Then
Difficult. Yes. Question of that. Ad interim was declined, has been admitted today, that is so and so, in the connected FAO 49 of 2024. Full stop. Para. Considering the facts and circumstances, comma, let notice be issued to the opposite parties Para. Let steps be taken for service of notice upon the opposite parties by আগতো কেনেকে কৈছো user process registered post দুইটা কৈছো নেকি by user process as well as by registered post full stop আগত notice issue returnable কৰি দিও notice issue returnable on 19th of July ঠিক আছে appeal to talk about 19th of July Para, in the interest of justice, comma, it is directed that since the matter of injunction is presently being considered, is presently under consideration by the learned trial court, comma, till the next date fixed, comma, the respondents are directed not to cause any nuisance or disturbance inside the suitland. Para, since this order has been passed ex parte, comma, the same may be reconsidered on the returnable date after appearance of the respondents. Okay. Yes, take steps. Next. Next date did this one, eh? Order. This is the next date. Yes, Mr. Item number. Mr. Sheikh, what is this?
My lord, it is a case, my lord, claiming compensation under Motor Vehicle Act. My lord.
It was rejected or what?
Yeah, rejected, my lord. Actually, case background is like this.
Yes.
Person died, my lord.
Hmm.
His brothers, sister and mother filed the claim case. And thereafter, wife implemented as respondent, claimant number 6. Now, what happened, my lord, after considering all these aspects, my lord, by impugn order, my lord, by impugn order, the case was dismissed. No compensation was allowed. That is this. So, my lord, I am referring to page
Mr. Hazarika, you for?
Yes, 10, my lord.
For the insurance company?
No, my lord, there is a delay of 78 days.
Oh.
In the delay petition, my lord, I was arrayed, I am the driver and owner of the vehicle.
Okay.
I was arrayed as respondent 1. Now, one copy of the memo of appeal has been served, my lord. And they have not made me party. Only because I have appeared in the delay continuation, my name is.
Why, Mr. Sheikh, you have deleted him from the array of parties? He was there in the IE for delay condonation.
Only insurance company has been made, but. Delay.
I think you should file a amended cost title.
Delay condonation, my lord, delay only 78 days.
That has been condoned, my lord.
My lord.
Now, Mr. Sheikh, what Mr. Hazarika is contending,
Yes, my lord.
that in the delay condonation application, he was made parties.
My lord.
And delay has been condoned. That's a different matter. But in the appeal, he has not been made party. You file an amended cost title.
My lord.
We will consider, okay? I heard Sri MS6 Learned Counsel for the appellant. Full stop, para. Sri P. Hazarika,
Well.
Learned Counsel, who appears has, however, submitted that his clients, namely the owner and driver, was made separate or same?
The same.
Owner and driver was made, owner slash driver was made party in the delay condonation application, namely numbered as Miss Case 1175 of 2015. However, his client has not been made party in the appeal. Full stop, para. Sri Sheikh, the Learned Counsel, has submitted that due to inadvertence, comma, arraying of the owner driver has been left out. Full stop, para. Sri Sheikh accordingly prays for and is granted 3 weeks time to file amended cost title in the appeal.
Much all right.
after filing of such
matter-
amended cost
matter
title,
may-
comma, the matter may be listed for admission.
Item 9.
May it please your lordship, something very peculiar happened in this case. The case of the claimant was that vehicle number AS01 AU 5467 was the offending vehicle. Two vehicles were involved. In one, the deceased was traveling, and in another, the offending vehicle was there. In the whole judgment, lordship, in different paragraphs, the court came to the finding that the Tata Sumo was the offending vehicle. But lordship, then at issue number 2, page 21, the court comes to the finding that that vehicle, AS01 AU 5467, was insured with Oriental Insurance Company. But that is not a fact. As per the claim petition, that vehicle was not insured with anyone. That vehicle did
The
not,
offending vehicle.
the offending vehicle. And
You are the Oriental Insurance.
Oriental Insurance
You said that you have, you are not the insurer of the offending vehicle.
of the offending vehicle.
And yet the liability has been settled with you.
Settle. And in the operative part, in the order part, the court brings in that Bajaj Discover, the motorcycle, and says that since the Oriental Insurance Company is insurer of this vehicle, the Oriental Insurance
Of which vehicle?
of AS19 TR 3292.
AS19
TR
TR.
3292.
This is what vehicle?
Bajaj Discover. It's a scooter.
Oh.
Sir.
Oh, Bajaj scooter.
Totally perverse judgment, lordship, because
Mr. You're from, sorry for? That's one number? 1 and 2, claimant. You are the insurer of the Bajaj scooty.
yes, we are the insurer of that. Actually, the court should have directed the owner of the
That Tata Sumo was insured or not?
no, that
No insurance.
They will also agree, lordship, that the
And
judgment
who are the owners and driver of Tata Sumo?
they are Miss Pedheshwari Brahma. She's the owner, and driver was Rindo Borkiar.
How much is the amount? That case?
5,97,000.
That case?
Yes.
How do you reconcile? You have a very valid point. At the same time, somebody has lost his life.
But they will get the company. I'm not saying but they will get from this owner, lordship. The court has made a wrong, totally wrong.
No,
in
in
fact,
this,
their case also, it is that vehicle was responsible. I think
in
the
this
court
process
agrees
of,
with that. I mean, the claimants will agree with that. Their claim
no,
petition,
that is okay, madam, but in this process of passing the buck and ultimately some family is suffering.
that is true, lordship, but
Heard Miss R.D. Mazumdar, learned counsel for the appellant, who has preferred this appeal under section 173 of the Motor Vehicles Act 1988 against the judgment and award dated 5/7/2022. Passed by the learned MACT Kokrajhar in MSC case number 14 of 2016. Full stop. It is submitted that while the deceased was riding,
no, he was pillion rider of
was a pillion rider of a scooty, and the offending vehicle was a Tata Sumo, the liability has been settled on the appellant insurance company, which was not connected with the offending vehicle. Full stop. Para. Admit. Call for the records. Sri Musahari, learned counsel, appears and accepts notice on behalf of respondents 1 and 2. Let memo of appeal along with enclosures be served upon him. What's the para? Steps for service of notice upon the respondent numbers 3, 4, 5, and 6 be taken by usual process. Steps within 2 days. Para. List after 6 weeks along with report on service as well as the receipt of records.
50%. They haven't filed a stay petition.
They have not filed for stay. We are not staying this.
First execution. Ipan lo ito, tapos.
Yes, please.
This case, he died due to the fall from the height of it, not due to the accident.
Due to fall from the
Height of it. When he was height of it, when he was working in a building of it. And we tried to establish that by producing evidence, but that was not considered.
and motor accident.
Yeah.
No convincing evidence was
adduced as per
to
the
prove that he fell down from height.
inquest report, as per the inquest
Inquest
report.
report is not the
Inquest report.
document to ascertain the fact.
What was the finding?
Finding lordship,
What was the finding on this issue?
Consider the charge and others, not consider our evidence, we
charge
use
sheet,
evidence. Kindly see our evidence,
lordship, kindly see
kindly see the page number 12.
Page number 12, 1, 2.
One.
Yes.
This is the DW1 logic. That I have been deputed to Deputy Superintendent as defense witness in the instance that I have said final deputed so the insurance company activities that the deputy by after receiving the appointment letter dated 18/12/2020, I visited the place of the claimant to collect necessary information like action taken care of the so-called place of occurrence.
Okay, we have read this. The PM report was there.
lordship.
PM report was there, okay?
What did PM say?
As per PM report, lordship,
No, we will come to you, Mr. Albert. We'll come to you. What does the PM say?
It was not denied, but
No. PM, the cause of death. Was this, Mr. Bhatto, was this investigator one of the witnesses?
But-
He was witness. He was cross-examined.
but only our investigator was examined.
That is it, investigator, he was cross-examined or not?
Yes,
In the tribunal?
yes.
What was his stand? See, your entire case is on the basis of a report by the investigator who made a inquiry and came to know that the deceased fell from a height. And therefore,
As per the inquest report also,
and those are the findings in the report.
and the medical legal report which was produced by them is also they ascertained that it was a false. That was also executed.
No, this investigator in his cross-examination, what questions were put to him?
That is the record.
Yes, Mr. Aruldo,
cross-examination part is there, lordship.
what was the questions?
I'm reading out.
Please
the-
read, please read.
The claim petition was filed in the year 2015. I have been deputed by the insurance company as investigator in this case on 18/12/20. Immediately upon receipt of the claim petition along with the notice, the insurance company appoints an investigator in this case. I was appointed to investigate the case. The PO is under jurisdiction of Lockheed PS and I visited there. I also visited the house of the claimant. I have not submitted any supporting document so that the deceased was 17 years old, as well as in the statement made in para 4 of the evidence on appeal. I have mentioned in para 4 that as per K.A. Hussain, this is sustained cerebral injury due to fall from height, but I have not submitted any document except my investigation report. I did not visit the concerned doctor who issued the Exhibit 6 and Exhibit 7. I visited Superintendent of SM Dev Hospital only. I also visited Forensic Department of SMCS and wrote a letter marked as Exhibit C. I verified the postmortem report. As per statement made in column 6, I was investigated into postmortem death sheet. I have not exhibited the investigation report prepared by Rohimuddin Forvia as the insurance company did not provide me. Another investigator was there. That report was provided or produced report. It is not a fact that by suppressing the real investigation, I have submitted a false report after investigating the
What was any police produced?
earlier
As- No, was any police personnel produced as a witness? It did not produce. Let us see the Form 54. What is your projection of facts? What has happened as per you?
Lordship, he was traveling in ambassador car, and due to rational and negligent driving of the ambassador car, he dashed against scooty, and he sustained injury on his head due to that accident, and subsequently he died during treatment.
How many occupants were there in the ambassador vehicle?
It is not reflected.
Was any co-occupants produced as witnesses?
No. Charge sheet is there.
Huh?
Charge sheet against the driver of the car.
Where is the
Was,
charge sheet? What is the name of the deceased?
Name of the deceased is Bijit Chanda.
Vijit Chanda. Okay. Where is this? Do you have the copy of the charge sheet?
Name of the deceased was not kept.
Mr. Bhatta, if you have a copy, please read.
Look,
If you have a copy of the charge sheet, please read.
in the statistic, the name of the deceased was not there.
No, what is there?
Another
Please read.
person died due to the accident. That is rider of the scooty.
Do you have a proper copy
And
of the
that
charge sheet?
case has been settled, Lordship, in Lok Adalat.
And a charge sheet has said what? Who had died?
Another
it's just-
occupant that was not denied the chief. That case was not denied the chief, that he was not open, but this person was subsequently.
No, as per the charge sheet, did somebody die?
Lordship,
Yes.
Who had died?
the rider of the scooty.
Not the occupant of the
No.
ambassador.
No.
No.
Then
It's not okay.
how do you connect?
No, one incident, Lordship,
yes,
one
yes.
charge sheet is filed.
One charge sheet, it has to state that at least there has to be some material that the
That is
occupant
not
of the.
reflected there. He died after.
Then what evidence, other than the oral evidence, what evidence do you have that the death was actually caused by a motor accident? What evidence did you adduce?
No eyewitness was examined. Lordship.
No, eyewitness may not be there. We are not insisting on an eyewitness.
Claimant was examined.
Claimant, how was he connected? He was not an occupant. He was not a co-occupant.
He was traveling in the ambassador car.
The deceased was traveling.
Lordship.
Was he traveling alone?
Oh, there is no.
Did anyone, co-occupant, come to the witness box, or the driver had come, or anyone? Now, in that case, if there was actually a death of an occupant of the ambassador car,
Yes.
there would be a police case by you. Where is the police case?
No, one police case is that is.
Police case is regarding the Lordship.
That is the death of the scooty owner, this thing. Accident might have been there between an ambassador and a scooter. But we are concerned whether in that accident, the death of this Chanda had occurred. You have to connect.
Lordship,
The Lordship medical legal report which they produced, Lordship,
Which one?
medical legal report which they produced, we verified it and found that it was a false.
Lordship, in the postmortem report, the TNT number is reflected.
Postmortem, what has been reflected?
TNT number.
Huh?
TNT number.
GD entry number. GD entry is what? What is the GD entry?
That was also not produced. Lordship.
Now, this case where charge sheet has been submitted, this is the case pertaining to an FIR lodged by you or somebody else?
Somebody else.
Somebody else, is it connected? Maybe one FIR, but is it connected to, does it state anything about the death of the present incumbent? Nothing. Yes, it's petitioner story. Why don't you read if you have a copy? Mr. Bhatta, the prosecution story of the case is that on so-and-so at about so-and-so, son of the complainant Sinha, coming with a scooty from so-and-so side to washroom perimeter on the way near point of
Lordship, in that prosecution is part of the claimant, Lordship.
has been-
Prosecution is stated that, Lordship, I am the housewife by profession. I filed a claim petition, but I cannot say the date of filing of the claim petition. I have not submitted any document in support of my two names as mentioned in the claim petition. My son made accident. I cannot say the date of accident, but it took place in the year 2015. Accident took place at Ujan Tarapur on National Highway. He was proceeding in an ambassador car. I cannot say the registration number of the ambassador car. The ambassador collided with a scooty due to which my son sustained injury and rider of the scooty died. I heard that my son was taken to Ujan Tarapur Hospital and thereafter to SMCH. He was admitted in SMCH as an injured patient. After about 4 months, he succumbed to his injury. I was not an eyewitness of the accident, but I heard that the accident took place between the ambassador car and the scooty, but I have not met parties, the insured and the insurer of the scooty. In this case, my son was 18 years old at the time of death. I have not submitted any certificate of deceased son. Deceased was a mason. I cannot say name of the contractor under whom the deceased used to work with the
Okay,
mason.
okay.
I have not
Okay,
submitted
okay,
any
okay.
income proof document of the deceased. Exhibit one.
Okay. Heard. Sri K.K. Bhatta, Learned Counsel for the Appellant Insurance Company, which has referred this appeal under section 173 of the Motor Vehicles Act 1988 against the judgment and award it is so and so. Para. It is submitted that the death was not connected with the accident and had occurred as a result of falling from a height. Full stop. The Learned Counsel has also submitted that the materials on record would show that the claim itself was a frivolous one, and by which an undue benefit was sought to be taken by connecting the deaths with an accident. Full stop. Para. Let no admit, call for the records Mr. Talukdar for
One.
Sri M. Talukdar, Learned Council, appears and accepts notice on behalf of respondent number 1. You have been served with a copy. Let steps be taken for service of notice upon respondent numbers 2 and 3 by registered post, by usual process. Steps within 2 days. List after 6 weeks for receipt of records. For report on report on receipt of records. Okay. I for this is an application filed for stay of the impugned judgment and order to the so passed by so. The connected appeal has been admitted today, that is so. The Learned Counsel Sri Bhatta, K.K. Bhatta has submitted, for the applicant has submitted that the death was not connected with the accident in question, and there are materials on record to show that the deceased had fell from a height and as a result of which the death was caused, and there is no nexus with the vehicular accident. Full stop para. Considering the above aspect, comma, the till the disposal of the appeal, comma, the impugned judgment in he however submits that the learned tribunal had failed to appreciate the aforesaid aspect. That's what considering the aforesaid facts and circumstances, comma, till the disposal of the appeal, the impugned judgment and award dated so and so shall remain suspended. Okay. Highest stands disposed of. M. Talukdar. Therefore, respondent number 1.
My lord, there is a cross appeal, my lord. Both the matters may be tagged together and put up.
Who has preferred the appeal?
Insurance company, my lord. And we are also the claimant, we have also prepared it.
For enhancement.
My lord.
Okay. You have the number of the
My
insurance
lord,
company?
14920.
Part 3 AK Sahewala. Who is AK Agarwala?
Go man. To the best of my knowledge.
Your clerk does not remember, he doesn't know you properly. See what is written?
My lord.
Or maybe he doesn't like you.
Perhaps, my lord. Shall I correct it?
No. Doesn't make a difference. It couldn't fill up for no. Court no.
Perhaps by the Mohori, my lord.
Okay, you correct it, correct it. AK Sahib Learned Counsel for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act, praying for enhancement of the award in the judgment and order dated passed by so and so and so and so. Full stop. The Learned Counsel has informed this court that in the meantime, comma, the insurance company has also preferred an appeal challenging the award which has been registered as MSC appeal
149 of 24.
149 of 24. 2024. Full stop para. Admit. And in that, I think record has been called for. Definitely.
My lord, record, yeah, LCR is called for.
Admit. Para. Since the LCR has already been called for in the connected appeal, comma, no separate order is necessary. Let steps be taken for service of notice upon the respondents be taken by user process.
Only one, my lord, because rest are In my case, rest are pro forma, my lord. Only we are claiming against the insurance company. So others are not.
At this stage, comma, Sri Sahiwala prays that steps may be taken only for the respondent number 1, against whom the present claim for enhancement would lie. Full stop. Para. Accordingly, steps be confined. Steps for service of notice be confined to the respondent number 1 at this stage. Full stop. Steps by usual process. List along with and MSC so and so.
My lord, can I date you?
In that case, we do not know.
My lord.
Item 12.
Mr. Sahiwala will say one thing. List after 6 weeks, along with report on service, report service, or it may be listed with MSC so and so. Item number 12. Yes, Mr. Park.
My lord, I filed this challenge the impugned judgment and
Kuntu, itu ni.
award, my lord.
Itu?
There is a 2 vehicles, my lord.
Okay. 2 vehicles.
2 vehicles. There is no whisper in their statement, my lord. There is just story also. The hit Tata AC, traveler to Tata AC. But there is no whisper that which direction, in which manner. But MVA report shows that their exhibit that there is a both of the head of both the vehicles are damaged.
Now, there are 2 vehicles.
2 vehicles.
You are the
But
insurer of
this was driving the vehicle of Tata AC.
Tata?
Tata AC. Small vehicle, man.
Tata Ace.
AC. Traveler is the insurer of the appellant. Insurer with the appellant.
There was another traveler.
A traveler.
That is also Tata.
Not Tata. It is a traveler of the passenger vehicle.
No, what is
Traveler
it?
minibus.
Minibus.
Yes.
Okay. Huh? What also? Traveler minibus. And you are the insurer of this traveler.
Traveler, man. But eyewitness says that.
Now what? There was a collision between these 2
Yes,
vehicles.
yes.
He was driving Tata Ace, and he passed
Yes.
away. He passed away.
Passive.
Now, what are your grounds of challenge?
So this matter in the eyewitness says that Tata AC coming from some gully. So it dashed, but which direction is not mentioned. But eyewitness says from the
No. What are your grounds? Those are okay.
ground is that, my lord, it is.
Why aren't you liable
My
to
lord,
indemnify?
yes. Because the court has not come to the conclusion that because of the charge sheet against the driver of the traveler, so court has settled the judgment against the applicant. So the eyewitness is very much specific, and also, my lord, is the MVI report. There is a head-on collision. That is also, it is on record, my lord. The court has not.
Which case?
Second is that, my lord, against the 40% of future prospect, there is no finding regarding the interest. That is why
Interest has been granted.
interest has been granted.
In that part, you will be.
Yes,
I think.
Because at this stage we pay only 50% of the minimum.
How much total?
If there is a, my lord, judgment is
No, total. How much?
total, my lord. Total, my lord, 21 lakh.
21 lakhs.
Maybe
But,
12 lakh.
Huh?
12 lakh.
Not. Even if we agree with you on the interest part on future prospect, that will not amount to so much. And the first ground is a very feeble, weak ground. Third, Sri RC Pal Learned Council for the appellant who has preferred this appeal under section 177 against censor. Where I submitted that the findings of the learned tribunal towards settling the appellant insurance company, which was the insurer of the traveler minibus, is not consistent with the materials available on record full stop. It is submitted that the deceased who was driving a Tata ACE had equally contributed to the accident. Full stop. The aspect of grant of interest on the future prospect has also been highlighted. Full
Right.
stop. Para admitted. Admit. Call her. Call for the records.
From University Milo 2, Kamrup.
Okay. You take steps by usual process within 2 days.
Yes, yes.
6 weeks report. huh?
Registered with 80 and.
Not registered, usual process.
Unless I is there. Milo.
I,
Yes. 1951.
সব কৰিবা হা এই কোনো ওপৰৰ হেৰিখিনিও লিখিবা ৰেকৰ্ড এই ছাবমিশ্যন দুটাও লিখিবা ছাবমিট যে এই দুটা যে আপুনি কনচিডাৰিং দি এবাভ কমা সেইটো তেনেকৈ বুলি the aforesaid grounds have been considered and this court is of the opinion that a blanket stay may not be justified. Full stop. Para. Therefore, in the interest of justice, this court directs that while that the impugned judgment and award dated so and so passed by so and so shall remain suspended, subject to payment of rupees 15 lakhs
Milo.
in the registry of this court.
Within 6 weeks.
That is up to you. The claimant would be at liberty to pray for release of the said amount as and when the same is deposited. I stand disposal.
50 also, my lord. It is a, my lord, injury case.
Yes.
My lord, it is specifically mentioned by the claimant that there is a add-on collision, my lord, in the 50.
50.
50.
Okay.
This is my first aspect of the matter. Second is the minor in the future basis, they have not come to the final.
Same, almost same.
And third is the minor, there is a head. Kindly see head. That's the higher side. Suppose my lord, pain and suffering. Then again, there is a
Okay, he also submits
disability is
that compensation awarded on other heads are on the higher side
yes.
than those prescribed by law. How much is the amount?
My lord, here is a my lord, 23 lakh. Is a my lord, disability is there. Disability is my lord only assessed is my lord amount is rupees my lord.
Yeah, 15 lakhs. Same.
Mal.
Same order. 15 lakhs the money. Okay. I stand disposed of.
Mal.
You take steps by usual process.
On the exact process.
Okay. And 6 weeks, huh? Kali ekhi nahi bodli. At a third ground over it. Heads to, huh? Higher side.
Only
deposit 15 lakhs.
Mal.
I disposed of.
Item 13.
The terror appeal.
Regarding service and record, my lord, the appeal is ready for hearing, my.
Yes, you are appearing for whom?
I responding number one method.
One you have appeared. Two. Only two respondents are there.
My lord, till it I got no money, my lord. No money, my lord. Till it I got no money.
Is there any stay order?
Already stay, my lord, in dated on
There is a stay order.
22, 2013, my lord.
There is a stay order. We'll have hear the appeal, entire appeal. It's a 13 appeal. We'll hear it. Take
Date may be
though Vaidi the order dated 19/9/2022, there were certain directions for fresh steps, comma. Both the respondent numbers 1 and 2 are represented by learned lawyers, namely your name
And Islam.
and Islam and Sri M.J. Kadir. Full stop. Para. Records है. Since the records have already been received and the appeal is of the year 2013, comma, the same may be listed for hearing immediately on the reopening of the summer vacations.
Obligation.
1-4. None appears for the appellant on call. Other side. S. Borthakur, M. Saikia, R. Goswami. Mr. Goswami was here. Madam Saikia, Madam Borthakur. I think Borthakur was here, even Saikia was here, I think. No, we are dismissing this matter. We want to record their presence since they were in the court. Okay, none appears for the appellant on call, whereas so-and-so appears for the insurance company. Full stop. There has been continuous absence of the appellant. There has been continuous non-representation of the appellant, and in fact, on the last date, 17/5/2024, the following order was passed. In view of the aforesaid position, this court has no other alternative but to dismiss this appeal for non-prosecution. Full stop.
May it please. My lord, I will take your lordship to the judgment at page 7.
Now, this is for orders today.
For orders, but what happened, my lord, there is a certain defect in this. My lord, if your lordship look at page 3,
Yes.
my lord, we sent a notice to the respondent number 2, but it came back saying that the address is not found. Ultimately, my lord, from the judgment, I could come to know that the opposite party number, there is the owner. My lord, during the pendency of the trial, he died, and the ex parte order was passed. If the main defect comes from there, against a dead man, my lord, no order can be passed. And the order was passed against the insurance company. Now, my lord, if insurance company is the indemnifier, if there is no order against the owner, there cannot be order against the insurance company. In fact, my lord.
But the policy would obviously cover his assigns or his
Yes, yes.
legal errors.
I'm not on that, man. I am on the position of law that the order will have to be passed against the owner, who is the main party. It is not necessary to pass an order against the insurance company. The moment order is passed against the owner, as indemnifier, my lord, we have to reimburse. Now, this is the point, my lord. How it can be passed ex parte if he died during the pendency of the trial? The judge ought to have passed an order directing the claimant to bring on record the name of the legal heir. My lord, that is the.
How
my
much
lord,
is the amount involved?
50%, the total amount is,
That case,
yes, 4,37,000. Out of that, 50% we have already paid.
and this can be taken up for disposal.
Disposal, my lord.
R2 has been served.
Beg your pardon.
Who is R2? Respond number 2.
R2, my lord, could not be because we took steps. It came back.
saying
Who-
that address is not found.
Who is R2?
The owner of the vehicle.
Owner has passed away, you had said.
Owner has passed away. That's the reason, my lord. There is some fault on our part because we ought not to have impeded the owner as a party because he has already expired.
Then what you have to, it's up to you, if I'll order one rule 10 or whatever.
Is the order one will applicable here?
Mm.
The question of substitution will not.
Not come, he had passed before even institution of this appeal.
Yes, yes, at the trial stage.
But if you, but at the same time, you are also taking that as a ground.
My lord, what I feel that the matter should go back to the trial court for passing an order against the owner after impleting the legal error. Or if your lordship think that it can be done here.
We'll consider after the vacation. Okay?
Yes.
Heard Sri as Dr. Learned Senior Counsel for the appellant and Mr. T. Gogoi. T. Gogoi Learned Counsel for the, that's one number one, first of para. The Learned Senior Counsel for the appellant has submitted that the respondent number 2, do made a party, had expired even during the pendency of the claim petition, and in fact, there was an order for proceeding ex parte against him. Full stop. Para. He has also raised certain issues as to whether the claim petition could have been continued without substituting the owner who had passed away in the meantime. Full stop. Para. Let this matter be listed after the summer vacations when these aspects would be considered.
Obliged.
But I think better for you to file order 1 rule 10. Will not go into those
Yes, yes.
technicalities in a matter of MSCP.
exactly.
Otherwise, civil matters we have been with you. Okay.
Yes. I'll
You can
file an-
instruct your clients to file order 1 rule 10.
Exactly, I'll do. that.
17.
May it please your lordship.
Yes.
We have taken dusty steps that we affidavit could not be filed. So further time may be required to file the
Upon whom?
respondent number 4. my lord.
For
Order
Talukdar
for-
for
Respondent number 1, 2, and 3.
okay. On the prayer of Ms. S. Musahari, learned counsel for the appellant, matter is adjourned by 3 weeks to enable filing of affidavit in support of the dusty service said to have been taken pursuant to the order dated 13/3/2024. Sri M. Talukdar, learned counsel is present for the respondents 1, 2, and 3.
Obliged.
Item 21.
Yes. Mr. Sakya?
Yeah, I'm for respondent number 1.
None appears for the appellant on call, whereas Sri A.J. Sakya, learned counsel is present for the respondent number 1, para, in the interest of justice. Matter is adjourned to enable the appellant to have another opportunity, to give another opportunity to the appellant. Okay.
Two 2018.
18 itself.
Yes, madam. Thereafter, an opportunity was given that if there is any legal representative, then they may file an application
Okay.
for substitution.
None appears for the appellant on call, whereas Sri A. Sattar, learned counsel, is present for the respondent. Full stop. There has been continuous default in on the part of the appellant in this case, full stop. In fact, this court on the last occasion, that is 7/6/2024, had made an observation that appropriate orders would be passed in case of further non-appearance. Full stop. Para, for ready reference, the said order is extracted here in below. Para. That apart, comma, Sri Sattar, the learned counsel has submitted that the appeal has also, appeal also stands abated from the year 2018 on the death of,
On the death of appellant,
on the death of the appellant,
yes.
and till now, no steps have been taken. Full stop. Para. In view of the aforesaid facts and circumstances, comma, without even going to the aspect of abatement, comma, the appeal is dismissed for non-prosecution.
There are 6 IA applications, my lord, all the 6 IA applications.
This A2IA giver kone asil.
In the call list, my lord, there are
A2IA,
6 IA.
A2IA giver kone asil. Section 5. It's you write this in section 5 and baki mein consequently in order since the order passed, since the application under section 5 of the Remediation Act misconstruence has been dismissed, stands dismissed, appeal stands dismissed. No, ऐसा कौन? बाकी में in the बाकी सब में लिखते हैं in IA number so and so filed for section 5, filed under section 5 of the Limitation Act has been dismissed today by the following order. Order quote करना है इसमें, उसमें सब में. In view of the above, the instant application is also dismissed or appeal भी dismissed. Appeal में अलग है. लेकिन IA का order सब में अलग अलग हो. Yes.
My lord, there is a two analogous matter. In this pilot case, the opposite my lord, he expired. In case of his my lord, we have substituted the persons, but none is appeared on behalf of them. Last occasion also the same thing, and record was called for.
For 1 PM, the state response.
He is for state response.
You're for the appellant in the MFA.
Yes,
Who has passed away?
my lord, the respondent, my lord, opposite my lord, he expired.
He passed away. Then he had filed application for substitution. Substitution.
Yes,
Substituted.
but notice was issued, but after that one, none is appeared, my lord.
No, substituted or not.
This is not probably not.
But notice was issued on the substitution.
My lord, the 24 is the same connected.
Oh, Mr. B. Gogoi had earlier appeared. Is he appearing for the substituted for the legal heirs whom you want substitution? B. Gogoi, I think.
But the cause this, my lord, not showing any name, my lord.
Okay. We'll have it immediately after the vacation. You're correct. Heard Sri P. Mohanto, learned counsel for the appellant who has also filed application for substitution of the respondent number 1. Full stop. It earlier appears. Now it appears that the original respondent number 1 had earlier appeared through counsel, whose name, however, has not been reflected in the cause list. Full stop. Para. Sri K.K. Bhattacharya, London State Council, is present. Para. In the interest of justice, list after the vacation by reflecting the name of Sri B. Gogoi as counsel for the respondent.
Masuk.
Mr. Jain, what is this?
In this case, respondent number 4, steps were taken, your lordship, but report has not come, but respondent number 4 is not required in this case, Your Honor. Even if an service is accepted on presumption, Your Honor, no adverse order can be passed against, because no liability of respondent number 4. It's a review petition, Your Honor.
Now, if you pray, we can strike off his name.
It can be, because there was no
Who is
liability.
for 1, 2, and 3?
And so far 1 and 2 are concerned, Your Honor. The notice was received by their wife.
1, 2, and 3.
1, 2.
And 3?
3, it is served as per office note.
So,
Office note.
3 BK Jain, learned counsel for the applicants / appellants submits that no relief is sought for against respondent number 4, and accordingly his name can be struck off from the array of parties. Full stop. Since the other respondent numbers 1, 2, and 3 have been served, list this case for I is for
It's for condonation of delay of 202 days. Only 200,
okay.
202 days. And none have appeared here.
Okay, उसके बाद last में क्या लिखे? He submits that the matter for that this present application may be considered. Full stop. Para 3 Jain, the learned counsel, by referring to the averments made in paragraphs 8 and 9, 8,
Yes.
9, and 10 of the petition, has submitted that the
Delay of-
applicants were prevented by sufficient reasons for not being able to prefer the review on time, and a delay of 202
days.
2 days has occasioned. Full stop. It is submitted that the aforesaid delay is not because of any negligence, intentional negligence. No, not because of any negligence or intentional.
No deliberate.
Intentional, and therefore the delay is required to be condoned. Full stop. Para. After hearing the learned counsel and taking into account the settled principles to be followed while adjudicating a petition for condonation of delay, namely to have a pragmatic and justice-oriented approach, the present application filed under Section 5 of the Limitation Act is allowed, and a delay of
202 days.
2 days in preferring the connected review petition is condoned. Full stop. In the review, right? The application filed under Section 5 for condonation, Section 5 of the Limitation Act for condonation of delay has been allowed today. That is so and so. Appeal review petition is to be registered and listed immediately after the vacation.
May I please, your lordship? Lordship, in this case, lordship, I have been directed to file an affidavit, lordship. So, but lordship, I have applied for certified copy of certain document from the record of this registry.
Okay. Sri P.P. Datta, learned counsel, prays for and is granted further time of 3 weeks to file the affidavit, which was required to be done in terms of the order dated 26/2/2024. Para. Oh, next. There is, what is the connected? Oh, that is the appeal. Okay. After consideration of this, you are appealing?
My lord,
Ms. S. Musari,
respondent number 3,
counsel is present for the respondent number 3.
apply.
May I please? Lordship, we have already prepared an appeal against the judgment. Lordship, dated 21/8/2012 in time, only 21 days delay in filing appeal. Lordship, thereafter the appeal was not listed for long time. We inquired thereafter, Lordship, we made complaint to the registry why appeal was not found in the registry. It was not numbered. Lordship, we have annexed the complaint to the registry, and we have also annexed the deposit receipt for rupees 25,000 for the judgment and award passed by the tribunal. The registry had accepted the 25,000 rupees and acknowledged the receipt of the check. But appeal has not been listed. That is why we have to file a separate appeal. After making complaint to the registry, we file a separate appeal. Again, another appeal with a petition for condonation appeal.
Where is the appeal? Records of the earlier appeal gone?
Record was not found at all. It was charged everywhere. 2 records were missed. 1 record has been found in the Lordship, in the new Lordship, the advocate associations in the office chamber. Lordship, as per office note dated 11/8/2022, notice on respondent number 1-2 has been charged, and they have filed objection to that effect that I have not enclosed any document that appeal has been filed. But subsequent to a file an affidavit enclosing the territory deposit amount received as well as complaint to the registry.
Who is appearing?
Name has been shown, I think, also. On earlier occasions, they have not appeared. That is why Lordship has adjourned the matter.
Heard Sri S.K. Goswami, learned counsel for the applicant, while none is present for the respondents. Full stop. The similar occasion was there on the, a similar circumstance was there on the last occasion. That is 5/6/2020. Similar situation, bolna. Circumstance, not bola, situation. Para. By this IA, the applicant has prayed. By this IA filed under Section 5 of the Limitation Act 1963, read with proviso to Section 173 of the Motor Vehicles Act, a prayer has been made for condonation of delay of 2693 days in preferring the appeal against judgment and award dated so-and-so, by so-and-so. It is submitted that initially an appeal was preferred in time
21/8/2012.
on 21/8, which initially an appeal was presented in time on 21/8/2012, along with the statutory deposit of rupees 25,000, which however had gone missing from the office of the from the filing section. Full stop. After complaint, even after complaint, the records could not be traced out, and therefore the applicant had to prefer the present appeal, in which and in the process, the delay has occurred. Full stop. Para. Para. As an objection was raised by the contesting respondent that no materials were placed before this court in support of the plea of filing or presenting an appeal earlier, the applicant has filed an additional affidavit to bring on record such documents and proof. Full stop para. The materials on record have been duly examined. Full stop para. This court is of the opinion that there was no of the opinion that no fault can be attributed for the delay in preferring the connected appeal due to the circumstances, due to the facts and circumstances narrated above. Full stop para. In view of the said discussion, comma, the instant application filed under Section 5 of the Limitation Act is allowed and a delay is condoned. Delay pehle delay condoned. The delay is condoned and the application is allowed. Okay. You write in the appeal, I-128/2021 filed for condonation of delay has been allowed today, that is so and so. The appeal may be registered and listed for admission after the vacation. Obliged. Yes, next.
Item 28.
Yes.
This case, we tried to serve notice on action number 2 by the society. But we could not indicate the address of the action number 2. Lordship, we may be allowed to
Paper publication.
paper.
Year for?
And for the claimant, Lord, respondent number 1.
1.
Yes, Lord. 1.
Shri K.K. Bhatto, Learned Counsel for the applicant, submits that the attempt to serve the respondent number 2 by Dusty was not successful as he could not be located. Full stop. Shri Espal,
Yes, sir.
Learned Counsel, is present for the respondent number 1 para. On the prayer of Shri Bhatto, comma, the applicant, Bhatto Learned Counsel, the applicant is allowed to serve notice upon the respondent number 2 by paper publication, which has to be done in one issue of the Assam Tribune and another issue of the Dainik Ahom. Full stop. The notice is to be vetted by the registry of this court and the next date is to be reflected. Full stop. Let the next date be fixed on. Yes.
Respondent number 2, your lordship, he is resident of Nagaland. As per the-
Then Nagaland, then we'll have you name 2 papers circulating in Nagaland. Hmm? Can you get back after 10-20 minutes? You can call somebody of your colleagues in Nagaland and okay. Paper ka naam mat dijiye, huh? You come back to us.
Local paper or Nagaland?
No, we specify the paper. You ask your clients to call anybody in Nagaland. It's a very easy thing. I think Guardian is there. Nagaland Guardian or something is there. But in one issue, naam kuch which have wide circulation in the state where the respondent number 2 belong, that is Nagaland. उसका बाद जो vetted होगा उसका बाद क्या होगा? Next date we'll have it on 26th. Is it okay? Can you do it before 26th of July? Okay, 26th July. And prior to the next date, comma, the applicant is also required to file an affidavit enclosing the copies of the concerned newspapers. You give the names. If not 2 papers, at least of 1. Nagaland vernacular English type. One English newspaper will do. There may not be any vernacular newspaper, no vernacular scripts. Nagaland Times is there.
Nagaland Times, only one paper is
Okay, Nagaland Times. One issue, huh? Nagaland Times.
For the respect one and
Hmm.
and for the respect one and
1 and 2. And the other one, other side?
I'm for 6, 7, 8, 9, 10, and
PK Roy, SK Chakraborty, where are they? A Chakraborty, M. Datta, whole team. Mr. PK Roy? None appears for the petitioner on call, whereas Sri T. Roy, Leonard Council for Respondent 1 and 2, and Sri K.
for
Bhattacharya,
6, 7, 8, 9,
Leonard
10.
State Council are present. Put the
Take part.
para in the interest of justice. List. You're for Mr. PK Roy. Which matter?
he's engaged in another courtroom. He'll come to sometime.
Okay. You should be here. Okay, don't write that, huh? A prayer for adjournment. Don't go away like this. A prayer for adjournment has been made on behalf of Sri P.K. Roy, Leonard Counsel for the Senior Counsel for the petitioner. Then in the interest of justice, list after revocation.
And 33.
Please, your lordship. It is a review petition lordship against the my lord Soda lordship. We pay for review advice in page 20 lordship.
20.
Lordship.
Yes.
Where my lordship directed us to deposit 50% the amount, awarded amount.
Hmm.
Now our ground is lordship on page 10 lordship.
Page 10, yes.
Lord.
Yes, which one?
And our High Court rights lordship annexed in page lordship.
Page 10, which ground?
23 lordship.
Which ground?
Page 23 lord.
Page 10, which ground?
Page 10 lordship. Ground number 2, 3 and 4 lordship.
You're invoking order 2780.
27 rule 8 lord.
You're the railways.
Railways lord. And lordship.
But these are not per se money decrease. These are in the form of money decrease in an accident case. What are your grounds of in the appeal?
Appeal lordship. It is there lordship. It is the particular person is not a bona fide passenger lord. And the body is found inside the track also lord. If it is fell down, then it will be outside the track lord.
Okay. A notice has been served.
In this review notice was not, otherwise other cases lordship has issued notice, we have taken steps lordship and person says not appeared lord.
Okay, heard. Sri K. Gokul and CGC. Who appears for the applicant in this review petition, by which review has been sought for with regard to the order dated 17/7/2023, passed in IA Civil 1889 of 2023, arising out of MFA 54 of 2023. Full stop, Tara. It is submitted that while granting the interim order, there was a direction for deposit of 50% of the awarded amount, full stop. The Learned Council has, Learned CGC has referred to the provisions of Order 27, Rule 8A of the CPC and has contended that the appellant being the railways, comma, it is exempted from making any deposit, full stop, para. The aforesaid point raised being a pure point of law, comma, this court is of the view that a case for exercising the review powers are made out, full stop, para. Accordingly, the order dated 17/7/2023 stands reviewed, and the condition for deposit of 50%, which was attached for suspending the award, is removed. Full stop. Review application accordingly stands allowed. Huh? Huh? MFA to MFA.
Item 34.
If this is Lordship, Lordship will peruse office note dated 25/24. Respondent one answer, but respondent one is appearing, Lordship. And for 3, Lordship, unserved notice without any postal remark, and for 2, Lordship, AD card has not received back as yet. SPR received. So for 2, we can await, Lordship.
Unserved notice of respondent one has been received back with postal.
But one is appearing, Lordship.
One has appeared already.
Yes, Lordship, okay. Name is also.
What about 3?
Lordship, that's for 3, unserved notice without any postal remark. So we can take, but the appeal is on quantum only, Lordship. Should we be waiting? That's why I wanted that if we wait for 2, Lordship, then later on, if need be, we can strike out because it's on quantum. But for now, I do not want to.
3, one who is appearing.
1, Lordship, Mr.
Name is not there in the cause list.
Oh, acha. No, because I know he appeared because he filed a petition also when that was
No,
allowed.
no, we are not doubting your statement, but he needs to know about this matter. Do Miss R.D. Mazumdar is Learned Council?
MJ Gogoi, Lordship. His name is MJ Gogoi.
No, the R.D. Mazumdar Learned Council for the appellant is present, comma. None appears for the respondents, full stop. It is, however, this court has, however, been informed that the respondent number 1 has entered appearance through a council whose name, however, is not reflecting in the cause list, full stop, para. List after the summer vacations by reflecting the name of the council for the respondent number 1 in the cause list.
Oblige, sir.
Item 35.
Itu আকৌ তলত নামি গৈছে এইটো কেমেৰাটো উঠাই দিব লাগিব বস উঠালে ভাল 35 Mr. Goswami? R. Goswami? Madam Chaudhary? Goswami was there or anybody from his chamber? No. বেলেগ ফাইলটো চোৱাচোন ওকালতমা দি আছে নে অভিয়াছলি ওকালতমা থাকিব None appears for the applicant. Full stop. It however appears that no names are reflected in the cause list. No names of counsel are reflected in the cause list. Full stop. It further appears from the last order dated 22/5/2024 of this court that even on that date, the names of the learned counsel were not reflected in the cause list. Full stop, para. Office to look into this aspect, aspect and list this case after the vacation by reflecting the names of the learned counsel for the applicant.
Item 26.
May I please? It's case for continuous delay Millard of 409 days. My learned pen has filed objection.
Okay.
Lordship, what happened, Millard? Judgment dated, judgment was passed in 12/5/2022. 12/5/2022.
By the tribunal.
Lordship, here I am the owner, Millard.
Okay.
And after that, Millard, by that judgment, Millard, direction was, award was allowed, and since during evidence, Millard, driving license was found to be proved, accordingly, found to be fake, Millard, during evidence, Millard. And accordingly, order was passed to pay the amount by pay and recovery order. Millard, after that, Millard, I came to the notice, Millard, knowledge, Millard, on 9/8/2023.
Did you contest the proceeding?
Lordship, I'm filed a notice. After that, since the beneficial legislation, Millard, not getting any.
Then what happened?
Lordship, after getting, Millard, since at the time of filing, I engaged it, and WSS file, Millard, and after that, Millard, I not, and after getting the notice from recovery, Millard, on 9.
No, after filing WS, you did not contest the case.
Lordship, only because that is the reason, Millard. Otherwise, even, Millard, when during evidence, Millard, driving license was found to be fake, Millard. Thereafter also, if Millard, learned court ought to have given opportunity to depart my that part of it. Not
No, what was it? Was such opportunity where you deprived of such opportunity? You are not deprived.
not deprived, but that much of information is not. Up
No,
to
see,
me.
once you filed your written statement,
Lordship.
you are expected to be there
Lord.
on the days of the proceeding when there was an evidence that the driving license may be held to be a fake license.
Lord.
You have the chance to cross-examine.
Lordship, that much of information not this to.
Who will give the information?
Actually, normally, what happened, Millard, in this type of case, Millard, after filing of WS, Millard,
It's your negligence of not appearing.
maybe, Millard, but since that's my case, I am stated in paragraph 4, 5, and 6.
Who is for the claimant?
Claimant of payment only made by
Who is for the claimant?
claimant, Millard, not appear till date, but
Served or not?
sir, Millard, there is an office note, Millard, Lordship will find office note that 2/4/2024. Notice already served to all the. Here issue between owner and influence.
Yes, what do you say, madam?
Lordship, there is a, delay is inordinate and no.
How much
sufficient-
delay?
409 days.
9 days. So when there is no cogent and sufficient explanation regarding such delay, Lordship. And secondly, Lordship, they are stating that the DL was paid, they did not participate in the proceeding, Lordship, though they're saying that they contested the case. That is their, Lordship, on their part, Lordship. This is not the court will not direct anyone to appear.
Correct, correct.
They have taken.
They could have processed them in.
Yes, notice received, they have received notice, Lordship. And the law is well settled, Lordship, in this regard. When the driving license was fake, it is proved by the insurance company, Lordship. The pay and recovery order is the settled law, Lordship, and we have already paid the amount to the claimant, Lordship. And for recovery now, we have filed an execution case. That notice received, after receiving that notice, my learned is apprentice before your Lordship. And in the learned timely ignore that part, Lordship. So Lordship, for their negligence, Lordship, this delay occurred, Lordship. And
So-
the settled position, Lordship, merit, there is no merit in the case, also, Lord.
So far as merit is concerned, my lord, section 149 2A B is the rule, my lord. There is an exception. There is a numbers of the judgment. It is to avoid the liability. It is not suffice only to prove the driving license is proved. The insurance has to also prove that there is an intentional breach. I have the judgment for 4 or 5 judgments since Leheru to last, my lord.
Now, they see their license, the information in a license can be of various natures.
Lord.
One may be that the license has spent its force, somehow you are not aware.
Lordship.
One may be it's a fake license
Lordship.
altogether.
Lordship.
What was the condition in your case?
Fake
Lordship, fake license.
Fake license.
Lordship,
Yes.
Lordship, I have the judgment.
Because
Lordship,
all judgments are discussed in the tribunal
Lordship,
decision.
what judgment Saban Kumar Singh is there?
Start from
No,
Swaran Singh.
in Swaran Singh, the first was
Yes,
Swaran Singh.
the first
Lordship,
one, it is
Lordship,
discussed.
that judgment is help me, Lord. Not only, not that. That judgment will help me. I have to, Lordship, kindly, these are the judgment, Lord.
No, we are not on the merits
Oh,
now.
Lord, therefore, Lord,
We are only on the aspect whether you are able to make out a case for condonation of delay of 409 days.
Lordship, I have stated in paragraph 4, 5, and 6. In normally, my lord, in Supreme Court also, my lord, while considering delay, my lord, merit is not taken in, not to be taken into consideration. It is on the basis of
We are not on the merits.
Lordship.
We
Lordship,
are
it
only
is-
trying to ascertain what are the
Lordship.
reasons assigned,
Lord.
whether those reasons appeal to a reasonable
Lordship,
mind.
there's I fairly admit, my lord, I participate, after submission of WS, my lord, I have no knowledge. No, I'm perhaps that part is my negligence, but so far as after getting information, I got the information only on, my lord, 9/8/2023.
From the executing court,
Lord, after receipt or notice, my lord.
from the executing court.
Lord. Also, therefore, that if apparently, my lord, judgment will help in my case, my lord, but because of this discussion lies on your lordship, my lord. Because since now, I have a judgment in Tukaram case, my lord.
What?
Regarding delay continuation, my lord.
What does it say?
Lordship.
What does it say? Tell us.
Lordship, if substantial justice and technical consideration are pitted, my lord, against each other, then the cause of substantial justice is to be preferred, my lord.
First, we have to see whether the delay has occasion because of your deliberate act, negligence.
Deliberate, maybe my lord, there is maybe some.
First, you have to overcome the aspect of negligence and deliberate act. Then we go to the aspect of substantial justice vis-a-vis technicalities.
I'm fairly submitting, my lord. I submitted my WS.
See, why is the Limitation Act there? Limitation Act, after expiry of limitation, a right accrues on the third party, on the second party. That right is a substantial right. You cannot just tinker with that right.
Lordship, here.
The moment limitation is over, right accrues.
Lordship, here question of law is involved, my lord, because if this type of issue is, my lord, left to be not decided only on because of this issue, my lord, then these will
Who is to be blamed?
lordship.
Have we said that we will
I
not
have
decide
taken
this
blame,
issue?
lord,
You
because
come
law
in
is
time,
settled. Otherwise, insurance company
There are
has to
hundreds
prove,
of
my lord.
cases every day filing. Come in time, we admit.
Lordship, Lordship has the discretion, my lord, if Lordship content delay, then this question may be considered during, my lord, hearing of my appeal, my lord.
What does your colleague say?
Lordship, he always object because
Always
I'm not
objects.
always
Lordship,
objecting. I'm not
normally,
always objecting.
no.
I'm
I'm
not
not
always
blaming, no,
objecting.
I'm
I-
just because he is in better
Objection is
position.
required in this case. Otherwise, Lordship, everyone will come in any case, Lordship. How many, they
Since
will
he,
not think of it.
and today's
think of
context is
delay.
that my fan is in the upper putting below.
It's an owner, Lordship.
That's
Not that
why.
he is a claimant, layman, does not know anything from
But
village he is coming.
fact remains
Is
that
there-
I
is there- Lordship
have
will,
the
Lordship will find in paragraph 6, Lordship,
Hmm.
elected member of President Karbi Anglong.
that
Autonomous
cannot be a Lord.
He cannot be a
He's the
Lordship layman, not knowing anything.
So you are elected representative.
Also,
Yes,
still
Lordship.
I'm the-
Because of him, 14 days delay, because he's to attend meeting and all.
14 days,
Yes.
406 days, 409 days.
For his own purpose, after getting the notice from the executing court, he himself delayed for another 14 days.
14 days is okay, but total 406 days.
For his meeting, for his personal meeting. He's not at all interested.
How much is the amount?
14 lakhs.
Already we have paid 12,79,600. We have already paid
14 lakhs.
12
That-
lakh 79.
Maybe he is a public, because he has some public obligation also. Because he is elected by the his constituency, people of the constituency. He has to.
He's the
You should be
owner.
happy to pay your
No,
people.
my lord.
Yes, Lordship.
He'll get more votes tomorrow.
Only because of he is the person of people of.
You're elected representative.
Lordship, that negligence, Lordship, it's not be taken into consideration.
You could not come to Guwahati
Yes.
from Diffu.
Gossip, that part after getting knowledge. Because I am explained
That-
regarding after getting knowledge what happened.
Okay. Third, Sri M. Mohanta Learned Counsel for the applicant. Also heard Ms. M. Chaudhary, Learned Counsel for Respondent number 1, who has filed objection. Full spera. The instant application has been filed under Section 5 of the Limitation Act, praying for condonation of delay of 409 days in preferring the connected appeal against judgment and order it is so and so passed by so and so and so and so. G4 Silo. Nagaon. MSCT Nagaon. It is submitted by Sri Mohanta, the Learned Counsel, that do the claim before the tribunal was contested by his client, who is the owner of the vehicle, by filing written statement, comma, subsequently, he was under the bona fide impression that since the vehicle was duly covered, comma, the owner, his client did not appear in further proceedings, full stop. Void the impugned judgment and award, comma, while awarding the compensation, comma, there is an observation to pay and recover in favor of the insurance company, full stop. He further submits that it is only on receipt of notice from the executing court that his client came to know about the impugned award, and accordingly, the appeal has been preferred, and in the aforesaid process, the delay of 409 days has occasioned, full stop. It is submitted that the delay is not deliberate and there was no negligence and negligence, full stop, per contra, Ms. M. Chaudhary, the learned counsel for the respondent number 1 insurance company, has submitted that the reasons sought to be relied upon are not at all acceptable or trustworthy, full stop. By drawing the attention of this court to the averments made in paragraph 6 of the application, the learned counsel has submitted that the applicant is an elected representative of the autonomous council and was not a layman, and therefore it is not believable that the applicant was not aware of the proceeding, full stop. She accordingly submits that the application be dismissed, full stop, An application filed for condonation of delay is required to be adjudicated by taking a justice-oriented and pragmatic approach, wherein substantial justice is to be given weightage over technicalities, full stop, not para. At the same time, the rights accrued upon the adverse party cannot be lightly brushed aside, full stop. The delay in the instant case is also a substantial one of 409 days, and as per the own admission, the applicant came to know about the judgment only on receipt of notice from the executing court on 9/8/2023. Full stop, Considering the aforesaid facts and circumstances, this court is of the view that while interest of justice may require condonation of the delay, the same has to be subjected to certain condition, full stop, Accordingly, the delay of 409 days is condoned and the IS stands allowed subject to a cost of rupees 5,000 to be paid to the Guwahati High Court Advocates Welfare Fund, full stop. IS stands disposed of. In the appeal, you write, in view of the wide and order dated so IA number 3036 of 2023 for condonation of delay has been allowed subject to deposit of cost, full stop. On furnishing proof of such deposit, the appeal is to be registered and listed for admission.
My name may be shown in the court.
The names of the learned counsel for the appellant Sri M. Mohanta and the learned counsel for the respondent insurance company, Ms. M. Chaudhary, be reflected in the cause list.
Mr. Blythe.
Item 37.
You need it. आर गोस्वामी क्यों नाम क्यों नहीं दिए? आर गोस्वामी, what is the नाम क्यों नहीं दिए? हाँ? तो क्यों दिया नहीं? None appears for the applicant on call. Full stop. It however appears that the cause list has not reflected the names of the council. Full stops. Registry is directed to verify and list this case after the vacation by reflecting the names of the learned counsel for the applicant in the cause list.
Not here in 39.
Yes.
Your Lordship, there is a cross objection by the claimant respondent. May be admitted and may be heard along with the.
You have been given
Lordship,
copy.
Yeah, I have given a copy, Lordship, but Lordship, the other respondents, they are not served. Notice was not. Service is not complete, proper 2 and 3 are concerned.
No, it's a MSc, it's a cross objection. We'll admit this. Then we'll ask him to take steps.
And then Lordship, regarding it will come up for admission. Lordship.
Admission only. We are taking for admission.
Last time it was.
Yes, Lord.
We're admitting this.
There is a delay in preferring this cross objection.
Is it?
Yes.
What is the delay?
And Lordship, dear Lordship, this
No, there is no
MSc
delay.
number is also different, Lordship.
Hmm?
MSc case number is different. And delay is, Lordship will find that this is, they have appeared, Lordship, this appeal was admitted on 13/9/2022, Lordship. This my appeal, Lordship, appeal filed with the insurance company. That was admitted on 13/9.
What is the impugned judgment?
Judgment was passed on. This is 7/12/2017. 12/2017.
Judgment of the tribunal.
Tribunal, Lordship, MSCT, number 1, Kamrup.
Okay.
It's a common judgment, Lordship. One is 1390 of 2015, MSCT case, and another one is 1391 of 2015. Common judgment for these two cases.
Then
Then we have filed an appeal. We have filed 2 appeals against this common judgment. One, my learned friend has filed this cross objection against 1390 in appeal number 691 of 2022. That is not correct. And secondly, Lordship, the admitted appeal was admitted on 13/9/2022, Lordship.
no, see, there is a common judgment in two motor accident claims. In 2 motor accident claims, there is a
Two motor accident, one motor accident arising out of same accident.
Your Lordship, in a particular accident, I being the claimant number 1 lost my daughter as well as my husband.
Yes.
In the same accident.
And-
For daughter,
Yes,
I
yes.
have preferred 2 claims.
It is what
Claims, Lordship.
that is what we are
Yes,
saying.
yes,
Same
yes,
accident.
MSc claims out of a same accident.
Yes,
Both were decided by a common judgment of
judgment.
7/12/2017.
yes, Lordship.
Both are being challenged by you
Yes,
in
Lordship.
separate appeals.
Yes.
Okay, now what has happened?
My learned friend is appearing on MSc appeal number 691/2022. He has filed cross objection, Lord.
Hmm.
This is cross objection number 1 of 2024, Lord.
Hmm.
This is one thing, this number is different, 1390/2000, it is 691 of 2022 relates to MSc case number 1391 of 2015.
Not connected.
Connected, your Lordship.
Connected 691/2022, Lordship,
That-
arising out of MSc case number 1391 of 15,
691 MSc appeal, MAC
Yes.
appeal,
arising out of 1391 of 15, MSc
MSCT.
case number 1391 of 15.
Okay, then he's filing cross examination here.
Your Lordship, may I explain?
One second.
MSc case number 1390 has been reflected in the cross objection.
Okay.
He has not filed cross objection in the other case.
Your
One
Lordship,
to that.
my cross
Secondly,
objection,
What is the other MSc appeal?
Other MSc appeal number is
6/1
690?
618.
Another one is lordship
618,
618 of 2022.
618 of 2022.
Yes, sir.
618 of 2022. This is MSCT of MSCT case number
MSC case number
1390.
1390 of 15.
And you say that this cross objection has given the
Relates
number
to
of
this one.
1390,
618. It relates
but
to-
it has been stated to be filed in 691.
Yes. And second,
Now-
regarding admission, regarding filing of this objection is regarding limitation lordship, appeal admitted on 13/9/2022.
Hmm.
Then lordship, they have received notice issued on 1/8/23 lordship and received on 28/23, and they filed Wakalatnama on 18/9/23.
Okay.
And they have filed this cross objection on 11/1/24.
What is the period of limitation?
Lordship, 1 month. Order 41 rule 20.
From 1 month from?
From, provided he has a first objection in the appellate court within 1 month from the date of service on him or his pleader of.
Then read it completely. Date fixed for hearing. Your Lordship, for cross objection, so far I understood, there is no requirement to file a delay application. It depends upon the satisfaction of the court. In one case, I have filed accompanied one delay application. This court have said that no such delay application is required because the provision says that satisfaction of the court. If the court is satisfied that prima facie ground is there in my cross objection, the court can easily condone my deal. And date for hearing means the date after the receipt of the LCR, the date will be fixed for hearing. It will be from that day, 1 month.
And Lordship, the
Just a
appeal,
minute, just a minute. Just a minute, please. Yes, any case law you are relying upon?
In one case, one order has been passed in cross objection that
No, any case law. Citation.
case law, Your Lordship, this is Supreme Court 2011 6 SCC 321.
Yes, what does it say?
I don't have the copy, Your Lordship.
What does
It
say?
says, Order 41 Rule 20 reduce aid rule on appeal against the default from filing appeal with the notice. Right of cross objector is not taken away in absolute term in case of such default. There is no indefeasible divestment of right of cross objector in case of a delay, and his right to file cross objections are protected even at a belated state by the discretion vested in the.
Discretion, how do you exercise the discretion? That whether you show the reasons for condemnation of delay are proper or not, that is exercise of discretion. When the statute has given a time, that you have to file it in 1 month.
No, that is one aspect. Another aspect is that MSc appeal and other regular appeal. In other regular appeal, what happened? The case is listed for admission hearing. Then the case for final hearing is fixed. Or admission hearing, for admission hearing, a date is fixed. But in this MSc appeal, if there is no delay, appeal is admitted on the first day.
Correct.
So what will be the date of hearing? It will be the date.
What do you understand by hearing in civil parlance? Hearing, are you trying to equate hearing with arguments?
No,
Are you trying to equate hearing with advancing of arguments? If you are trying that, you are mistaken.
Your Lordship.
You consult the CPC. What is the meaning of hearing? Hearing, what we understand, normally you are practicing in the High Court. Hearing means the hearing column that will go for final arguments. That is not the parlance which I understood under the civil procedure. Hearing starts even before adducing of evidence. Don't go by the cause list that what is hearing. I have a hearing today. Matter has been admitted is for hearing. It's a different connotation. Arguments, hearing, they're all different. You come to have your CPC. Have the CPC. Do you have the CPC?
Lordship, regarding issuance of notice, Lordship, because there is no permit. So owner and driver is required to pick up notice should go, Lordship, because
No.
you reply to that.
No, we are on the aspect of whether there
Yes.
needs to be a application for condonation of delay.
Yes.
Mr. Mondal, you may be correct in contending that it's a matter of discretion, but even for condonation of delay, the matter of discretion comes in. So without the condonation petition, where do I apply my discretion?
Your Lordship, what happened in a case, there was a delay of some.
Suppose in a writ petition where per se the limitation act is not applicable, but there is inordinate delay. You may not be required to file a separate section 5 application, but you are definitely required to make adequate explanation why you could not come to the court in time. While you exercise discretion, it has to be based on certain reasons. Where do I get the reasons? I cannot assume reasons until you plead. And pleadings were in the petition. The court reads the pleadings. If it's satisfied, exercise discretion in the favor of the party.
Your Lordship, in a similar MSc case, I have filed one, I have accompanied one
No, that you have
delay application.
That you have already told.
Yes.
That we have heard, but we are not very impressed, to be fair.
Your Lordship,
Whether a court accepts or not is a different purpose. But where is your application? Or you show us something. We may be wrong in assuming, but show us something that is not required. Why we are asking is this the provision of law, namely 22, which is the basis to accept a cross-examination, which is almost an exception, that you are not even required to file a separate appeal.
Yes.
In the same appeal you can file. Therefore, it has to be treated as an appeal, and you know the law. Once you file the cross-examination, you are transposed to the position of an appellant. We independently, just like a counterclaim in a
yes.
In a civil suit. Even the suit fails, counterclaim is allowed. Counterclaimant becomes the plaintiff and okay. Now here, your right is based on 22. 22 gives a particular time within 1 month from date of receipt of notice. Now, if that is given, then how do you exclude the application of limitation? There may be some case clause. You try to have some case clause.
Yes, sir. Your Lordship, this number has been wrongly written by me.
That also you need to.
Cross objection 1 in MSc appeal 618.
How do you correct? We do not know.
I will like to withdraw this cross objection.
Then again it will be delay.
Afresh, Your Lordship.
Again there will be a delay.
Otherwise,
you file an IA to
correct.
We'll We don't want to.
Otherwise, your lordship, how can I put the explanation what happened, why there is a delay?
No, for delay condemnation, you need to file a separate application. If tomorrow it appears that a section 5 is indeed necessary, file section 5, we'll consider. But before that, you need to also correct what Madam has pointed out. Okay.
Your lordship, in this case, the two stay application is there. It is pending since 2022. No order has been passed. And
Stay for?
stay for execution of the decree.
Lordship,
You go for
after-
execution.
Yes, Lordship, because the law court record was called for Lordship by this honorable court.
You go for execution.
Problem is this, that whenever execution proceedings start, the company simply says that appeal is pending. And the court accept that. That is the basic
Then
problem.
you come for revision.
Even though they have filed the stay application, it ought to be disposed of. Otherwise.
Are you pressing the stay
No, no,
application?
no. Admitted stay will be
Then
there
delay-
after
delay-
13/9/2022, Lordship.
Then-
It has come for the first time on 19/6/20. And they have appeared in.
Your
the
appeal has been admitted otherwise, madam. Has your appeal been admitted?
Admitted.
Appeal admitted, Lordship. Appeal admitted on, Lordship is admitted.
Or thereafter only have filed your cross
Admitted 13/9/2022.
You take step, you take instruction, take steps. Heard 3, D. Mondal, learned counsel for the Hertz, Miss M. Chaudhary, learned Heard 3, D. Mondal, learned counsel for the cross objector, whereas Miss M. Chaudhary appears for the opposite party insurance company.
One.
Which is the appellant in the connected appeal. Full stop para. Sri Mondal, the learned counsel, however, prays for and is granted 3 weeks time to obtain instructions and take steps. Full stop para. Please stop the 3 weeks. We are not indicating anything.
So far, stay application.
If they are not pressing,
Then it can be
Lordship,
disposed of as not pressed.
Lordship, the service.
Then I can pursue the
This
execution
case,
proceeding.
Lordship, regarding service, Lordship. Service is, so far as two name is shown in the cause list, Lordship. So far as fee is concerned, because owner and driver is necessary party. Because we are challenging here the permit.
in your appeal,
Yes, Lord.
we'll pass orders, let him
Yes,
first.
Lord.
Today it is
Yes,
for
Lord.
cross-examination, let him take.
And next is also, Lordship.
And
same-
if you are, he may be right if you are not pressing the stay, at least if you do not dismiss, then we'll make a statement that the
On the
stay,
next date, Lordship.
on the
because
that the stay prayer is not pressed at the moment and is deferred, then you can at least show
because
this.
law court record was called for, Lord.
No, that has nothing to do with the stay application.
Now, regarding Lordship, next case, Lordship, 618, there is also, response number 2 appeared, so for three, it is awaited, Lord.
No, 618 will not passing any, which case is separate.
Second one, 39.
39.
Okay, what is your prayer?
I am appealing in this case, Lordship.
Heard
Hearing.
Miss
Yeah.
39, heard MSM Chaudhary, learned counsel for the appellant. Full stop. Do Sri D. Mondal, learned counsel, appears for response number 1, comma. Response number 2 has been served or not?
2 and 3, similar case in other case 2 appeared in delay petition, Lordship. And his name is also shown in the cause list. And
Here-
3, Lordship, 3, it has not yet been received back. Response number AD.
The service upon the response numbers 2 and 3 is inconclusive. Full stop. List after 4 weeks, 3 weeks.
Also, can it be on 2nd of August?
No, we are not putting a date. We're granting him time. 3 weeks
Yes.
along with MSC appeal
618 of
619.
8, 618.
No, this is 618.
Yes, yes.
Along with
691.
691.
691.
691. Okay.
2020.
Okay, next.
Must oblige, Lordship.
Obliged.
Item 40.
May I please your lordship? Just a minute. Yes.
Your Lordship, we filed a title suit
Hmm.
for confirmation of our cast position and for eviction of the defendant, the present respondent. And along with it, we filed an application under Order 39, Rule 1(2), paying for ad interim injunction,
Okay.
Your Lordship.
Hmm.
Now, Your Lordship, the learned court below by Annexure 8, page 256,
Yeah.
refused to grant ad interim injunction on the grounds that we have not annexed any photograph of the illegal construction. Then, on the subsequent date, we filed
Photographs.
Annexure 9. It has been reflected in the Annexure 9 itself to page 57, Your Lordship. Last page of your petition.
Yes.
The petitioner represents the opposite party appeared through the duly engaged counsel and have filed petition.
Now
number
what happened
10.
thereafter?
Yes, Your Lordship.
Thereafter, what happened?
Thereafter, as it has been refused to grant ad interim injunction, we approach this honorable court by filing the instant appeal, Your Lordship. And this honorable court filed order dated 8/5/2024, directed that till the returnable date, no construction work shall be undertaken under the schedule E to M. These are the schedule which are the offshoot of schedule A, schedule E to M. In spite of that, Your Lordship, they carried on construction, particularly the respondent number 3. So, Your Lordship, our limited prayer is that let the learned court, trial court, decide the title suit. Until then, both the parties should be restrained from carry out any illegal construction of the disputed land.
No, if there is a violation of the injunction, did you come for any action to be taken for violation?
No, my learned, the appellant, Your Lordship, instead of approaching the court, on the next day, there was the date fixed for the trial court. Therein, he submitted the trial court order, the case was listed on 10, wherein their counsel are also present, and the copy of this order was placed before the trial court, and that was kept on record, Your Lordship.
Then what happened?
Then.
Not record, madam, not record.
Thereafter, Your Lordship, the other respondent stopped their illegal, but respondent number 3, he continued with the illegal construction.
Then what steps did you take?
The appellant filed a 144 petition.
That's a different one.
There
No,
is a different part.
for violation of the injunction, what did you do?
In fact,
Nothing.
it has been listed today itself, and in the meantime, no steps have been taken before the honorable court. Only 144 petition has been.
No, we are not on the listing of this appeal after the first date.
Yes.
We say that this court on 8/5/2022 had passed some ad interim injunction. Okay. And that you say that respondent number 3 has been violating in making constructions.
Yes.
So did you take any steps for?
We approached the various authorities, deputy commissioners.
No, not authority.
No.
For violation, 3A petition, not there.
No.
Okay, now what do you want?
Now, Your Lordship, the ad interim order may be passed and the trial may be proceeded, Your Lord. The case may be remanded.
No, why ad interim? What about happened to your injunction application?
Injunction application, they have fixed for objection, written objection. And the next date is.
The court will decide the injunction application.
Milord, I am for the all respondents. Yeah, Milord, this is a quite wrong statement passed, Milord, by my learned friend. But there is no violation regarding this interim order. And Milord, issues.
No, Mr. Sinha.
Yes.
Mr. Sinha, see, what we are just thinking aloud or contemplating is that this High Court's order is almost 2 years old. There is some protection to Mr. Mazumdar.
Yes.
So far as the construction or change in the nature and character of the suit land is
Yes,
concerned
yes,
by
yes,
making
ma'am.
construction.
Yes.
And this has been continued for the last, as I have just mentioned, 2 years. So instead of having the matter here and the main prayer for injunction still under consideration,
Yes.
wherein you have filed your objection.
Yes.
See, the refusal was only on the ad interim injunction. The consideration or passing of the final orders on the injunction application is still there.
Yes.
So we'll remand this matter to the,
Yes,
and
madam.
this,
Yes.
this order of 8-5 will remain till disposal of the injunction application. I think this is
a humble prayer.
heard. Sri R. Mazumdar, learned counsel for the appellant. Full stop. Also heard Sri S. Sinha, learned counsel for the respondables. 1, 025. Full stop.
Lord, compose submission. So for injunction is concerned, that whatever order passed by the Honorable Court, it is not disobeyed and
We are not saying that it will be disobeyed. We are not passing any orders of disobedience. We are directing the learned court to expeditiously dispose of the injunction application.
actually, there is quite different contradiction texts are here in this case. So
We are not even entering into the marriage. We have noticed that 2 years, rightly or wrongly, there is an order by this court continuing. Why should it continue here when the primary authority is the judge? Let the trial court decide. Both your rights needs to be protected. Because of the pendency, neither the trial court will decide, and 2 years have passed.
otherwise, the matter is not stayed till now.
Your lordship,
Not stayed.
not 2 years.
That means not stayed.
No.
Matter is continuing.
Order is of 8/5/2024.
20?
8/5/2024.
24?
Yes,
You said 22.
No. In this case,
24.
the appeal itself is of 2024.
Okay. Oh.
So, let us file our reply, my lord.
Oh, if you want to file reply,
Yes,
we'll-
ma'am. Yes.
Oh, we were under the impression it's 2 years. Okay.
It's a recent order.
Okay.
But it will serve your lordship. The case can be remanded with the attending injunction.
No, if he wants to file, sir,
Yes, my lord.
but that option is also there.
Yes.
Since
No, my lord, I'll file the reply in this case. Here it is.
Hearts, লিখিব আগৰখিনি হা Hearts আগৰখিনি লিখি থাকিব আৰু এছ চিহ্ন থাকিব হা Sri Sinha, the learned counsel for the respondents, pray for and is granted 3 weeks time to file objection in this appeal.
Yes. Till then, your lordship,
It is there.
it was up to returnable date, your
The interim,
8/5.
the interim order passed earlier to continue till the next returnable date. Full stop. List on, we give a date.
Yes,
till
my lord,
the-
date, my lord,
List on,
2024,
list on 29th of July.
29, 20,
Monday.
30,
30 Tuesday, no, 31st then.
31.
We can have it on 26th. Is it okay?
No, 25.
26th. Oh, sorry, July, yes, 26th of July.
No.
Not possible. Then 31st of July.
Obliged.
Okay.
Obliged.
What you want?
Yeah, please, ma'am. I'm appearing for the sole respondent. Today I have only filed wakalat number. So 2 weeks.
Regarding transfer,
Yes, 2 weeks I may be granted to file objection. But today is fixed for consideration of the interim order. As the next date is fixed on 11th of July.
then you file it within just immediately on the reopening. We'll consider the interim order.
Yes.
On Wednesday we'll fix. We are opening on Monday. Wednesday we'll
Well,
fix.
11th July is the next date. They can take time for. Lordship can have on 17th July.
We'll have it on 17th July. Okay.
Before that I will. file.
Heard Sri A.K. Gupta. What is this, Mr. Gupta?
My lord, I have served for the justice, my lord, although they have refused and my lord. by
But they have already appeared.
taking- appeared, registered posting.
I heard Sri A.K. Gupta, learned counsel for the petitioner who has also referred to the affidavit filed. When did you file? Today?
No.
24th July, 24th June. Affidavit filed today with regard to the justice service, full stop, para. Your name?
N. Hassan.
Sri N. Hassan has, however, Sri N. Hassan Learned Council has, however, entered appearance for the sole respondent and prays for some time to file his objection, full stop, para. Taking into consideration the observation of this court regarding consideration of the prayer for interim order, comma, let this case be listed next on 17th of July 2024, on which date the interim prayer would be considered. Okay.
Okay.
You let the name of, have you filed Mr. Hassan, your Wakalatnama?
Yes, so I filed today.
Let the name of Sri M. Hassan,
N.
N. Hassan be reflected in the cause list
Obliged.
as counsel for the respondent. Yes.
My lord, office note dated 11/6/2024, my lord. Maybe, my lord. 2, 3, and 6 return answer. And already 5 appeared, my lord. Question number 5 appeared. 1 and 4, my lord. Evaluation. So, my lord, I have to take base step upon 2, 3, and 5. 5, 6. 6 I will definitely get. 2, 3 will be a problem. 6, my lord, dispute branch of the United India Insurance Company. I have to find out.
Sharma for 5.
Respondent for 5, but created.
What do you do, Mrs. Sharma? What will you do? 2, 3, 6
2, 3, my lord.
insufficient. 1 and 4 not yet arrived. Answer.
1, 4 probably will come. Yes, yes, sir. Then, my lord, 1, 2, 3, and 5, 5, 6. 6 I will get definitely at this, my lord. But 2, 3 I have to find out. Again, I may be allowed to take steps, my lord.
No, we wait for some time, then
Yes.
because it will not be proper if we direct you to take steps for few of the respondents. Taking into heard Sri J. Sharma, Learned Counsel for the applicant, whereas Sri S.P. Sharma, Learned Counsel, has appeared for the respondent number 5, insurance company. What's the para? Sri J. Sharma, Learned Counsel, has referred to the office note dated 11/6/2024 regarding the reports on service, full stop. He accordingly prays for, he prays for and is accordingly granted 3 weeks time. No, I don't get this. Taking into consideration the said office note, comma, matter is adjourned by 3 weeks for fresh report on service.
Well,
depending on which, comma, consequential orders would be passed.
well, obliged.
Lordship, I am appearing for respondent number 2 and
File objection.
no, Lordship, it's a delay of 13 days, but
No objection. Now appears for the applicant on call, whereas Sri H. Chandran, Learned Counsel, has appeared for respondent numbers 2 and 3. Full stop, para. In the interest of justice, list after a week.
much obliged.
Yes.
May I please, Lord?
File petition note.
That is not back, right?
In the delay condemnation?
No, your lordship.
Release for
Okay. This is your appeal.
our.
He has filed for release of the amount.
Yes, yes.
Let the objection come, we'll consider. What is the objection for?
Our vehicle is not involved as our bill.
Okay. Heard Sri Deem on the learned counsel for the applicant. Full stop. I also heard Sri A.J. Saikya, learned counsel for the opposite party insurance company, who submits that objection has been filed, which however has not been tagged with the case records. Full stop. Para. List immediately on the reopening along with the objection.
Your
for-
lordship, in this case, the owner filed written state, categorically admitted the involvement of his vehicle, and my learned friend is submitting that the involvement of the vehicle. I have the written statement with.
What are your grounds of appeal, Mr. Saikya? That the vehicle was not involved.
Yes.
And they have not
Evidence is
reduced any
there.
evidence.
Okay, next.
Oblige, your
45, Mr. Saikya.
Firstly, there is delay of 26 days.
First day.
First.
Notice, huh? Is this Saikya notice? Section 5 will likheba. And steps by registered post with AD, 2 days. List after 6 weeks along with service report. Section 5 will प्रथम रजी देखा हाँ is this क्या नाम लिखिए okay
There is delay of 81 days.
for section 5 81 days is this क्या registered post with AD steps huh steps within 2 days list after 6 weeks along with service report. Todo también lo que me reason, ¿eh? Camera to todo también dice,